Okay, we are being live streamed. We are starting day 3 of the matter of.
We're not recording yet, Chair.
Oh, okay. I thought we were. Yes, we are now.
It's like we are now.
They're two separate buttons, so it takes a second.
Okay,
Thank you.
docket.
You are ready.
We are starting the 3rd day of the hearing of docket number 23 NETE 585 STG. Witness Daniel Mayers is still under oath. And as we left it, it is time for NextEra's redirect.
Thank you. Good morning, Chair Duffy. I would just note at the outset that 1 or 2 questions on redirect may get into confidential competitive information. We've sort of saved those to the very end. I just wanted to give you a heads up that we might request to go into confidential competitive session in a moment or 2.
And at that time, everyone who has signed an NDA will be allowed.
No.
Oh, competitive.
Yeah, it would just be staff and.
I'm sorry, staff and NextEra.
Staff.
Well, and I believe outside counsel for Evergy can stay as well.
Right. Okay, go ahead, begin.
Okay, thank you. Good morning, Mr. Mayers.
Good morning.
During the commissioner's questioning yesterday, there were several questions regarding impacts on landowners along the portion of the project that parallels Evergy's line. Do you recall that line of questioning?
Yes, I do.
And do you know the approximate percentage of land that has been acquired along that section?
So 55% of the easements along the Evergy co-location area have been acquired.
And do you know the number of landowners that have agreed to easements along this section?
To date, 43 landowners have agreed to the easements along that section of the 77 total required.
Thank you. Commissioner Keene asked you a series of questions regarding NETE's use of concrete poles. And I believe you stated that concrete poles have performed exceedingly well in Florida, even withstanding Hurricane Ian. Do you recall that line of questioning?
I do.
Could you please explain how have concrete poles performed outside the state of Florida? For example, Kansas, Texas, Oklahoma.
Sure. While NETE Southwest's affiliate, FPL, has 35 years of experience using the round concrete poles, near affiliates have installed over 750 miles of concrete poles in Texas going back to 2009, Oklahoma going back to 2014, and in Kansas going back to 2016. And the performance to date has been as expected. These rugged poles are built for durability and the long-term use. We've had no problems to date. They require no maintenance, and they've held up very well in extreme weather conditions, such as through Winter Storm Uri in 2021.
Commissioner Keene asked you a series of questions yesterday regarding oil and gas leases and split mineral interests. Do you recall that line of questioning?
I do.
If there's a landowner that owns subsurface rights to develop oil and gas, would NETE Southwest work with that landowner to accommodate those rights?
Yes, absolutely. NETE Southwest would work with the landowner. To date, of the 64 gas leases that we are aware of, no landowner has approached NETE Southwest concerning the use of their subsurface rights. NETE Southwest's affiliates have worked with landowners in New Mexico, Texas, Oklahoma, Kentucky, Virginia, Louisiana, Arkansas, among others.
Is it NETE Southwest's practice to routinely work with a landowner to identify an appropriate location for surface access?
Yes, absolutely. In general, NETE Southwest and their affiliates try and route transmission lines to avoid oil and gas infrastructure. As we've shown on this project, if a landowner has oil and gas leases and notifies us, during easement negotiations, we will work with that landowner to adjust the easements and or the pole location, the micrositing we discussed yesterday. And once the landowner decides, that they want to exercise their rights to explore, we will work with that landowner so as not to interfere with the operation of the transmission line. This would include, of course, no drilling directly under the transmission line or within the designated distance to maintain the safety of both the drilling crew and then, of course, ensure the integrity and the reliability of the transmission line itself. If a landowner wants to set up a drill rig pad and it can be accommodated on easement while ensuring a safe work distance, NETE will work with that request. If a landowner wants to set up off right-of-way a pad and horizontally directionally drill to obtain their mineral rights within the easement, our easement, he or she may do so, provided they don't undermine the foundation. I'm sure we can find a satisfactory location for the landowner to exercise his rights. And if the landowner does not own the surface rights, NETE will work directly with the surface right holder to obtain a waiver, surface rights waiver agreement within the easement area. And we would need to do this anyway for liability reasons. So NETE will work with both the surface right holder and the landowner directly to identify a suitable area for surface access. In many cases, NETE will even agree to reserve acreage to accommodate a drill pad location off easement. For instance, if we had just some acreage that we could go ahead and subscribe. So the easement exists both above and below ground, and any installation or drilling operation across or within that right-of-way would have to be approved, making sure it did not affect the operation and or future maintenance on the line. And, like, for example, if a landowner wanted to develop their land and put a road across the right-of-way, we would review that design and verify that the NESC clearance over the road could be maintained, and the road was not so close to the structure as to create a problem for maintenance of that particular structure.
Thank you. And I believe you just briefly mentioned that mineral rights holders are still able to directionally drill below the easement area. Is that correct?
Yes, absolutely. As I just stated, we'll support any landowner rights to directionally drill on the easement and grant it over their property. We prefer the drill pads not to be located in the easement itself, and we have an obligation to maintain the NESC requirements, and we have NERC requirements to ensure the reliability of the line. So in most cases, there's no issue directionally drilling in easement areas. The drilling depths are substantially deeper than our infrastructure, and our pole set depth is going to be approximately 20 to 30 feet, and these will be several hundred feet below that. In our experience, mineral rights holders may access all the subsurface minerals with a drill pad located a mile or more away, in some cases, from the desired area if that they're planning to explore. And this is common practice, and we have had instances across our fleet and the affiliates where subsurface drilling occurs without any type of interruption to the landowner.
Thank you. Turning to a different subject, staff council asked you several questions regarding the planned 43 guide structures, 27 of which are in cultivated land. Is it NETE's practice to work with landowners to microsite these guide structures to minimize impacts on landowners?
Yes, it is. In every case where a landowner is willing to negotiate, we are pursuing an amicable solution. To date, NETE has adjusted 99 structures based on landowner requests. And regarding the guide structures, of the 27 structures in cultivated land, 9 of those easements have already been acquired. And of the 16 remaining of the 43 structures in uncultivated lands, 11 easements have been acquired. Therefore, to date, we've acquired 20 of the 43 easements, or approximately 47% of the guide easements necessary. I believe, that this shows we are working with the landowners to locate guide structures within the easement to the landowner's satisfaction.
Thank you. Chair Duffy, at this time, we have just one or two redirect questions that could get into confidential competitive information. Who'd request executive session, please?
Okay.
The McGee's will object to the commission hearing any evidence that's not publicly available and allow for us to be able to hear it, notwithstanding the McGee's refusal to sign a confidentiality agreement.
Mr. Kimmel, your request is denied. Okay, I think the best way to do this, how did we anticipate this, Michelle, that we go to a breakout room, but we need the names of folks?
Correct.
for the
Who has
breakout?
not signed the disclosure so that I know who to exclude? I guess,
David-
because that's probably easier.
Michelle, David will provide you the names. He's doing that right now.
Yeah, I'm getting ready to send you an email.
Okay,
Okay, thank you. I was just waiting on that.
all right.
Commissioner Duffy, would you please ask NextEra to identify the topics that they identify or they're going to consider to be confidential so that we have at least have an understanding of what the discussion is going to be. Just to say that this is confidential business information without an indication of why they consider the questions to be confidential seems to be lacking.
Ms. Kallenbach, would you like to respond to that, please?
Thank you. The questions will likely get into the cost impacts of dead ends over highway crossings and elimination of guide structures, which those costs could be backed into, and that information could pertain to future competitive bids, which I believe is one of the categories that's protected as confidential competitive pursuant to the protective order in this case.
Thank you, Ms. Kallenbach. Okay, I believe Michelle does have the list. And we will be moving folks to the breakout room. If we can just pause, please. Thank you.
And Commissioner Duffy, we probably need to make sure if there are internal folks co-located with outside counsel, that they are not in the room with their outside counsel when they move to the breakout room. If that makes sense.
Yes, that's true. So I'm requesting that of the parties who are moving to the breakout room, make sure those folks are who is admitted, the list that we have.
Evergy confirms that's the case.
Yeah.
Thank you, Trevor.
I'm still waiting on the email.
It's momentarily coming here.
Thank you.
And after you send that, I'd go ahead and prepare the one for this afternoon during a down time. So when we go into it this afternoon, because it'll be the opposite, it will be.
You all are unmuted, just so you know.
Okay.
So I thought they were doing it.
Okay, we are coming back into session. And we will, I'm assuming everybody is that was on is back in their chairs. Okay, very
They're
good.
flooding
We're
in
still
now.
waiting on the court reporter.
Oh, there's Denise.
Sure.
Okay, we're coming back in into session, and at this point, we will be asking commissioners for any questions, and I will start with Commissioner Keen. Any questions of the witness, Daniel Mayers?
Yes, thank you, Chair Duffy. Good morning, Mr. Mayers. If you could step maybe or set the microphone a little bit closer, I'd appreciate that.
Good morning.
Good morning to you. At the outset, I want to thank you once again for your testimony yesterday. I think it was most instructive and informational. Just as a footnote to the questions that and the colloquy that you had on redirect with Ms. Kallenbach with respect to oil and gas interests, I would just add two footnotes to that. Number one is that these areas of Southeast Kansas that this proposed line would encompass, these are incredibly shallow relative to even Western Kansas standards. These are very shallow zones, such that horizontal drilling is impractical and not cost effective in virtually all cases within the area of your line. The other thing I would just state by way of a background is that it would probably lesser be with respect to oil and gas surface facilities, it would lesser be the landowners who would have a concern than it would be the oil and gas lessee or the operator. They would be the ones that have the concerns under the contractual relationship. Just for purposes of clarity, I would just add that to the record. I take at face value all of the representations, and I appreciate the representations you've made about your willingness to work in conjunction with the industry to facilitate a mutually beneficial outcome. Just a couple of questions for me, Mr. Mayers. Let's go back to this issue of concrete poles once again and see if I can kind of finish up, at least in my mind's eyes, the questions I have about that. And you're the ideal person to ask these questions of. Help me if you would. What sorts of, with respect to construction and safety and these concrete poles, what sorts of technical or approval processes or clearances have these concrete transmission poles you customarily utilize passed or been subjected to? Is there anything the equivalent of a good housekeeping seal?
No, but okay. So, the concrete pole technology that Valmont has the patents on, Valmont becomes the engineer of record. We provide the design loads through our engineer of record, Burns and McDonald, and we give it to Valmont's engineers. Valmont's well qualified. They work with the American Concrete Institute. They have their own engineering staff. They review those loads and they come up with designs. The loads themselves, the design of the poles, or you end up with a sealed drawing associated with each and every one of our designs. So, we trust that Valmont has the appropriate staff to do the work. And as I've said, there are tens of thousands of poles, not just used by NextEra, but used by multiple other large utilities, including, AEP, Duke, Southern Company, Entergy. I've already mentioned our own affiliates. So I'm not quite sure what the commission's reluctance is with concrete poles, but I can assure you that, other than there not being a good housekeeping stamp of approval on it, that it is a engineered design product and it meets all the specific requirements to be used as a transmission structure. And while we don't have 80 years worth of life in them yet, at FPL, we've got more than 35 years. And as I mentioned this morning in Texas, we've got 14 years of experience with them. And they hold up exceptionally well, and they do exceptionally well in harsh weather conditions. So we are very comfortable. We have a lot of trust in Valmont. We spend a lot of time with them to ensure that each and every concrete pole that's designed and put on a project will meet or exceed the specific requirements of its duty.
Well, I thank you again for the detailed answer. I'm not so sure that with respect to one of your observations there, I'm not so sure that the commission necessarily has any hesitancy with respect to this. I think I'm just asking questions that I think help us perform due diligence in determining the parameters of what the benefits and or the parameters of the acceptability of these poles. And
Well,
just
I
for
apologize if I took
no,
it out of
I
context.
didn't. I took no offense. There's no offense, none taken. But I think that's all I'm trying to ferret out. Let me re-ask that question in a slightly different way here. Would I be correct in concluding that these concrete poles are presently compliant with accepted industry standards and qualified for utility industry use, such that the approval for their use is complete and acceptable to the Southwest Power Pool under the RFP and the notice to construct for use on the Wolf Creek to Blackberry line without further condition, qualification, or limitation?
Yes.
Okay. Two more questions and I'm done. Thank you for your indulgence, Mr. Mayers. I'm not asking you in this question to opine pro or con at all about the double circuit option. But I want to ask as a general observation, given your experience in transmission, wouldn't it be more accommodative to a variety of surface land uses if the surface users were only required to cope with one instead of two sets of transmission line infrastructures?
In general, yes. If there was only one set of structures, it would be potentially less impactful. But as we've stated, our concrete pole footprint is quite small. And where we get the opportunity to work with landowners on guide easements, we believe that it is a more cost-effective solution to use, to allow us to use the guide structures. But your point is, would it be less impactful? Yes, simply because there's one less structure in that easement.
Again, thank you for the detail of your answer. I appreciate it very much. One final question from me. This won't necessitate an executive session. It won't bear in any specific way on confidential information because I'm asking for the conclusion of the witness. My question is this. In the bidding process for the Wolf Creek to Blackberry line, I'm looking for a conclusion, Mr. Mayers. In your opinion, was a major factor in the difference between your bid and the bid of other bidders, including Evergy, due in major part to the fact that you were using concrete in lieu of steel poles?
Was it a major factor? In
the amount of your bid? Was it a major factor in the amount of your bid versus the amount of their bids? Just a general observation.
Yeah, I'm not privy to the bid specs, of the other bids. I don't, the fact that the Southwest Power Pool had a very extensive bid evaluation process. We won on a number of accounts, and I'm not aware that there was any specific comment made by SPP related to concrete structures at all. I apologize. I'm not quite sure. I'm not 100% sure of your question itself. What I'm saying is I don't think that we have that SPP said, concrete wouldn't work. They did their evaluation. They had their independent team review it, and I assume that their findings were that concrete poles were adequate and sufficient, and therefore the combination of concrete and steel would work in this particular instance.
I really wasn't asking whether they were approving or disapproving of concrete. I was asking more in terms of when you put the bid together, the cost you have to cover. And the margin you want to have, generally speaking. And I wasn't asking about concrete versus steel in terms of acceptability. I was asking in terms of the bid itself, and you may not have the answer. Were the costs associated with using those different kinds of poles a major factor in the difference between your bid total amount and the bid total amount of others who didn't use these concrete poles? That was the question.
I'm only aware of what went into our bid. I'm not aware of what went into the other bids.
Fair enough. Thank you, sir. I appreciate your indulgence once again. I have no further questions of Mr. Mayor.
Thank you. Commissioner French, questions of the witness?
No, I have no additional questions.
Okay, Mr. Mayers, if I could, as it relates to the co-located approximately 23, 25 miles of the route, in your bid, were there any guide structures on that section of the route?
Yes, there would have been guide structures on that section of the route.
And of the number of poles on that part of the route, what percentage of them in your proposal right now are guide or number?
So let me think about this.
And while you're thinking about it, my thought is, again, going back to Commissioner Keene's question of, the landowner having to deal with one set of poles or two. And it's not just one set of poles or two, it's also the second with potentially a guide wire. And I'm just trying to understand how many poles we're talking about out of that section.
Okay. So we've mentioned that there are 43 landowners that have agreed to easements out of 77 total required. And of those 43, we had 20 agreements already signed, which leaves us with 23, additional easements. So when I talk about the easement requirements, it was because of the guide structures.
Okay, so you're saying that 43 out of 77 landowners in that section will have guide poles on their property?
No,
Okay,
I'm sorry. So we have 77 total easements along that section. 43
Okay.
of those folks have agreed to them. Okay. Of those 43 landowners, then we have 27 in cultivated land, and the balance, in this case, 16 are in uncultivated lands. We have 25 guide structures that only have 4 guys each. When you think in terms of the number of guys, and there's been a number of pictures that have been shown. There have been a number of guys, the number of guys for the particular polls. You have 17 of those guide structures only have 4, and 8 in uncultivated land only have 4.
okay, but I still don't think I'm getting to the total. And if you don't have it right now, you can provide that with me. And let me be clear, in that section, and I do want cultivated land and pasture or what, hay meadow or whatever. But of the 77 landowners in the section, how many of them will have to deal with polls with guys? And secondly, how many polls out of the total number of polls in that section will be guide? And you can either give me percentages or numbers, but maybe that's something you guys can pull together over the course of the day and just share that later.
Okay.
Thank you. Okay.
Sorry for any confusion.
No, that's fine. I appreciate it. Okay, Mr. Mayers, you've had a long 2 days, and if you will virtually step down, I appreciate it.
Thank you very much.
Thank you. Our next witness is Rochelle McGee Smart. Is she available? Oh, wait. Is she available, or are we going to skip to Stephen Vetch? I'm sorry, we did agree to that.
We did agree, Ms. McGee Smart is not available right now, as the commission knows. She is AIing cows. I do anticipate her to be available a little after 10 o'clock.
Very good. Okay, we will move on to witness Stephen Vetch. And Denise, if you could swear a witness in, please.
Okay. Mr. Vetch, please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Very good. I'm trying to, is that you, Trevor Wolford?
Yes, it is.
Okay, good. Trevor, is this your witness?
Yes.
Okay, please continue. Trevor, you are on mute.
Because when I did what we had to do is off, on, off.
I'm sorry, we're having some technical difficulty.
I understand.
I think it's been resolved. No, I'll ask again. Please state your full name and position title for the record.
My name is Steve Vetch. I'm the Vice President of Transmission at Evergy.
Are you the same Steve Vetch who submitted written direct testimony and testimony in response to public comments on behalf of Evergy in this docket?
Yes, I am.
Is there anything in your written testimony that you wish to correct?
Yeah, I have one correction. It's in the response to public comments testimony, page 5, footnote at the bottom. And it says D staff direct testimony prepared by Leo M. Hanos, filed February 21st, 2023, page 6. The page 6 should read page 5.
Anything else?
No, sir.
We are getting some feedback. Mr.
Your answer
Wolford,
would be substantially the
Mr.
same
Wolford.
given the written testimony.
Yes, they would.
excuse me, Mr.
Madam
Wolford.
Chair, I
You-
move for admission of Mr. Vetch's direct testimony filed February 21st, 2023.
Mr. Wolford, you
As well as
need
his
to-
testimony response.
Pause for
Comments
questions.
filed March 31st, 2023.
Mr. Wolford, I'm sorry, you're going to have to repeat all that. We're hearing strong reverberations from all your microphones. So if you could just turn off all the mics except for yours, but you will have to repeat what you just said for the record. We could not hear that. Well, it was just ringing.
Okay.
Okay, if you'll start over there with your witness, that would be helpful.
You go over by him.
Madam Chair, we're having difficulty. We'll resolve that.
Actually, it appears to be working. Let's try.
Madam Chair,
Yes,
is this better?
yes, it is. Thank you.
Okay, thank you. I apologize.
No, that's okay. Please proceed.
Okay. I assume you would like me to begin the examination from the beginning?
I believe that's correct, Ms. Haas, to start over.
Actually, I did get the correction that Mr. Vetch made regarding page 5.
Okay, if we can start from that point.
And I apologize again, I couldn't hear. what you-
She did get the correction about page 5, so you can start right after that point.
So, Mr. Vetch, if examined orally today, your answers would be substantially similar to those provided in your written direct testimony,
That is correct.
as well as your testimony response to public comments.
Yes.
Excuse me.
Now, Madam Chair, I move.
We're still
very
getting
good.
echo.
If I
Mr.
may
Vetch's
suggest-
direct testimony, which
if
was
I may
filed on
suggest-
Hold
February
on,
21st.
folks. Hold
2020.
on, folks. All right, hold on.
If I may suggest, I think the answer to this, Trevor, if you can hear me, this is Dwight Keene. The answer to this is that you can't simultaneously turn your mic on and have Mr. Vetch turn his on. You have to ask your question, then you have to turn your mic off, have him turn his on so that you have one mic at a time. And I think that'll overcome this reverberation problem.
Thank you. Jaden, I know you're on and you wanted to speak. Can you help us here?
Yes, I would just confirm what Commissioner Keene said. If you guys are in the same room, you can't have two mics on at the same time.
Okay.
Can you get
all right.
close enough to the same laptop so that you can both speak into that, or are you able to turn mute your mic when you're done talking and the next person is going to speak. Because we really can't make out what you're saying when both mics are on.
Okay. We've done that now.
All right, very good. All right, please proceed. Let's
Okay.
start again after the page 5 correction. We'll try it again. Third time is a charm. Thank you.
So if examined today orally, your testimony or the answers to the questions would be substantially the same as the answers given in your written testimony. Yes. Madam Chair, I now move for admission of Mr. Vetch's direct testimony of February 21, 2023, as well as his testimony in response to public comments of March 31st, 2023.
Thank you. Any objections? Hearing none, it's so ordered. Okay, we will begin with commission questions. And I'm starting with Commissioner Keen. Do you have questions of this witness, please?
I have several questions of this witness. Thank you. Good morning, Mr. Vetch.
Good morning, Commissioner Keen.
Let's start right out. With respect to your 161 kV line that may run parallel to NextEra's proposed Wolf Creek to Blackberry line, when do you anticipate upgrading or changing out the poles on that line?
We don't have a definitive date assigned right at the moment, Commissioner Keen. We are evaluating a window of when this line will likely be replaced. Certainly within the next 10 years due to its age, condition, and just the priority of the line. It's certainly due and eligible for replacement. So I would say certainly within the next 10 years. There's been a date in the testimony here in the last couple of days about 2030. I think that's a fair estimate of when the line would likely be completed by, but I don't believe there's any formal and definite plans to have it completed at that time.
Okay, thank you. Well, I would just observe that 10 years is one heck of a long time. Let me ask the next question, if I might. With regard to it's either 25 or 22 miles, give or take, evidently, where the proposed NextEra line and your lines would be parallel. My question is this. Had Evergy prevailed in the SPP bidding process in lieu of NextEra, how was Evergy proposing to deal with these 25 miles of this proposed new 345 kV line in conjunction with the existing Evergy line? For example, would you have replaced and double circuited your own poles?
Commissioner, I'm happy to answer your question, but I would ask that we convene in a confidential session to do so.
I guess I would ask why.
Because we think the answer is proprietary.
Okay.
And competitive.
All right. I'll leave that up for others to decide.
Commissioner King, can we save that question till the end? And there may be others that come up that they have a similar response, and we'll make a determination at that point. Put a pin in that question for right now.
The question is so incredibly generic that I'm having a hard time seeing how it is truly confidential. And I'm trying to think of the scope of my examination and how your suggestion, how I could accommodate that. That's such a generic question. Holy cow.
Well, why don't we ask the attorney to respond as to why this is not something that can be shared right now. Mr. Wolford?
Yeah.
Okay. Can you hear me?
Yes.
Okay. This wades into Evergy's bid to SPP, and that was provided under confidential competitive designation in the COC docket. Wasn't part of the record, and it's not part of the record here, and wasn't provided in discovery. So it wades into the confidential competitive bid with SPP.
At this point, I believe that is correct. And so here with this witness, we may move into a closed breakout session. Commissioner Keen, if you would like to go on and ask any other questions.
Commissioner, I'd like to note my objection for the record.
So noted.
The McGee,
I'm sorry. Go ahead. I cut you off. Go ahead.
sufficient evidence of confidentiality has not been provided here. Simple assertions generically that it could touch on information submitted to another party in another matter is that could touch on economics is simply not enough to demonstrate that this is confidential information.
I'm going to deny your objection at this point. Thank you.
Chair Duffy, the
Why don't we get the commissioners in a breakout room at this point? I would appreciate that.
okay.
Just commissioners and council?
Yeah.
Yes, commissioners and council. Thank you,
Give me just
Michelle.
a second.
So you can hear me there if I do that?
Okay, everyone. Are we all back? Yes, we are back. I see all three commissioners, and Commissioner Keen, you were in the process of questions. If you would care to resume.
Okay, thank you, Chair Duffy. I will. I'm going to do my best, even though I may disagree with your counsel, Mr. Vetch. I'm going to do my very best to ask questions that are not within the ambit of the confidential category that we've set up. And there may be reasonable people could have differences about that, but I'm going to do my very best. My first question for you is, let's go back to this existing 161 kV line. How old is that line? How old are those poles?
They were put into service in 1965.
And within the scheme of wooden poles, where is that in the lifespan of what you feel comfortable with for safety and construction considerations?
My perspective is that they are nearing, if not beyond, in some cases, the end of their useful life.
What would be the end of, what would that be? How many years would that be, the useful life?
It's really hard to answer the question with a definitive date, Commissioner. I'm not trying to be evasive, but there's really, like I said in my initial response, a range of time when the poles get to a certain age where they're much more likely to fail than they would have before we got into that kind of time frame. So certainly we're what I think at the beginning of that time where we would likely see additional more common or more frequent failures.
Fair enough. So what is that range? What is that range in terms of years? Yes.
So we talked at the beginning. We're looking at about a 10-year range that we would like to have the line completed within the next 10 years.
I get that. What's the range of the life expectancy of the existing lines? You said it, you didn't want to give a definite date. I accept that. Yeah. What is the range of the useful life of these kinds of poles that are in existence now?
Yeah, the range is in the 50 to 60 year time range.
Okay. In your opinion, have you been present throughout the hearing, Mr. Vetch, to hear the testimony of prior witnesses?
Yes, sir.
Mayors?
Yes, sir.
Okay, good. In your opinion, is the NextEra concrete pole construction proposed by NextEra, is it inadequate in some way?
I don't believe so.
Okay. Could pole construction be chosen that was adequate to support both your lines and theirs?
Yes.
Could that be concrete pole construction?
It potentially could be. I think we're at that stage where that has yet to be determined. Our design standards call for a davit arm as part of the hardware that would be attached to the pole. We historically haven't used concrete poles, so we're not familiar with what the design criteria would need to be for a concrete pole to support our design standard. We're certainly not objecting to the material used for the pole, either concrete, steel, wood, only that we're able to connect our davit arms to it, and the pole would be substantial enough to hold that arm.
So when you're saying there was some uncertainty, it isn't necessarily uncertainty about whether or not they meet industry standards. It's uncertainty about the fact that you don't have experience utilizing them. Am I correct?
We certainly don't have experience utilizing concrete poles. I think where the delay is here is in the analysis of attaching a davit arm onto a concrete pole and what would be the requirement of the concrete pole to accommodate that davit arm.
All right. When you conducted your analysis with NextEra regarding the double circuit option at the behest of the commission, To what extent did you evaluate or take into consideration the economic impacts and effects on affected landowner property rights from either using or not using the double circuit option?
So I want to make sure I understand your question, so I'll ask you for clarification.
Sure.
My understanding of the question is that we were asked to evaluate a double circuit option and work with NextEra to that end, to which we did. How it impacted landowners. So we took two different approaches. One was the potential building of that line in the existing easement of our current 161 line, and then also a secondary greenfield option, which was building both circuits in a new easement, 150-foot easement in and by itself, which isn't in existence today.
And what conclusions did you reach with respect to the impacts that these things would have on the property rights of landowners? Was that within the scope of what you did?
Yeah, so using the existing easement is it provides an incremental impact to the landowners. We would need certainly to widen the current corridor, which our 161 line is in existing. So in what we think to be 50 to 75 additional feet of easement, the new corridor would be, certainly a new corridor in its entirety of 150 feet. So, the differences to landowners could potentially be 75 additional feet of right of way if we were to go on a new corridor.
Pardon me, didn't mean to talk over you. So that is as juxtaposed to alternative suggestions which have suggested that they abut.
Yes, that is correct.
Okay. Okay, I want to do a share screen on part of your pre-filed direct testimony if I can. Michelle, if you could bring up page 6 of Mr. Vetch's pre-filed direct testimony, please. That is not it. Neither is that, I don't think.
Chair Keen, that is page 6, the other one.
This
Is
is
there something else you were looking for?
No, this is from Mr. Vetch's pre-filed testimony here. It isn't dated on the cover. Commission received it on 2/21/23. Page 6 begins with the answer at the top is yes. That's how page 6 begins. It says yes, even if it could.
Is in the March 31st in response to public demands.
Yeah, I think the item you have up is the response to public comments. Well, we need his other direct testimony, the one filed on February 21st.
That's correct.
David will have to look for that one.
Okay.
All right, I found it. Give me just a second.
Okay.
I think I just sent it to Michelle if she gets it.
That's the page. That's the page. If you would, for this, I think we're there for now. I want to refer, can you see this on your screen, Mr. Vetch?
Yes, I can.
Okay, I want to focus on, for the moment here, on lines 6 through 10. And I'll read this into the record and you follow along to see if I'm correct here. This is your response to a question. And it is, if a co-located portion of the project were ordered, the entire project would have to be restudied by SPP and potentially pulled and reissued for bid. That delay, if only a year or two or more, would delay the economic benefits to the region of $14 million per year. So if you might save a few $1,000,000 in one-time construction costs, you would lose 14 million in economic benefits, operational flexibility and reliability benefits for each year the project is delayed. Pardon me, those are lines 6 through 11, not 10. Did I read those correctly, Mr. Bench?
Yes, sir.
Okay. In conjunction with the prior question I asked about your analysis of impacts to landowners, assuming that your concerns, as you've stated here, are correct, I'm still asking, basically, what about the permanent long-term economic effects on landowners by not double circuiting? Especially though for those lands that are along that 25 or 22 mile portion that would be subjected to potentially 2 sets of transmission lines. I just don't see any mention anywhere in an analysis or a concern about these interests. Help me out. Is there something there I'm not missing? There's something there I'm missing, pardon me.
Yeah, just for clarity, is the question that in the $14 million per year delay cost, that there's no valuation for the potential or the impact to landowners for having 2 separate lines parallel to each other?
I couldn't have asked the question better. That's exactly the question.
There is no economic evaluation in my testimony here, written testimony that you have displayed here, that calculates the cost of the landowner concerns in the $14 million that I'm aware of.
Okay, that's fair enough. I appreciate the candor of your answer, frankly. Help me, and I appreciate your helping me out with the question as well. Next question for you is, within the Evergy transmission system, generally, do you use double circuiting on your own poles within that system?
Yeah, on circuits that we own, operate, and construct, we absolutely double circuit transmission on our system.
Why do you do that? What advantages do you have to doing that? What are the circumstances under which you do that?
Circumstances where we would do that are more common as we're coming into a substation, as the transmission lines are converging somewhat to a single point. We also do that to what we call shrink our footprint, which is something that we try to do when we have an opportunity to do so. In urban transmission construction, it's more prevalent than it would be in rural construction. But certainly, when the opportunity presents itself as a potential option, we certainly will try our best to double circuit our lines.
All right, thank you for that.
Mhm.
Let me, Michelle, on the same page there, if you would scroll down a little bit so we can pick up lines 16 through 21. Okay. Yes, thank you. Can you see that, Mr. Vetch?
Yes, I can.
Okay. Let me, for the benefit of the record and for the court reporter, let me read into the record the pertinent part of your answer that I'm reading in. For purposes of perspective, the question is set out on line 12, and it is, what are some of the other practical implications? And your answer beginning on line 16 in pertinent part is, the request for proposals, in paren, in quotes, RFP, in paren, in quotes, issued by SBP did not contemplate co-locating part of the line with Evergy to construct a newly designed double circuit line. Furthermore, SBP's competitive bid criteria prohibit the use of another utility's existing easement. So it could be argued in a protest or lawsuit that the notice to construct, in paren, in quotes, NTC, in quotes, in paren, for the project would need to be revoked. Any such challenge would necessarily involve long delays and threaten the needed in-service date. That's the end of the excerpt from the pre-filed testimony. Mr. Vetch, have I read through fairly or correctly those lines?
Yes.
Okay. This is a lead into a question. It's a little tricky to get this on the record, but I'm going to try to do justice to both the record and in fairness to you as well. Our IT people are not able to readily bring up for display here in this screen share application the transcript from the prior docket. That's the CCN docket. For the record, that's docket number 22-NETE-4199-COC. So with your indulgence, I'm going to reference certain parts of that transcript, and I'll try to identify rather specifically what I'm reading from here for the benefit of your understanding. So bear with me here for just a moment, if you would. The portions of the transcript I'm referring to is the testimony of Mr. Kelsey Allen. Mr. Allen is the lead engineer for the Southwest Power Pool. And what I'm reading in here is his testimony on cross-examination at the evidentiary hearing for the CCN docket that I have already indicated. You follow where I'm coming from here?
Yes, sir.
Okay. And for the record, I'm turning to that transcript, of that prior transcript, page 330.
Commissioner Keen, Commissioner Keen, sorry to interrupt. We can get the transcript for a share screen if you prefer.
Your voice reverberated, but I thought you indicated you could obtain these.
Yes, very easily, Commissioner Keen. We have access to that transcript and can put it up on the page.
If that's his preference.
What I'm looking for, Brian, to start with is page 330.
Page 330. All right, give us a moment. We'll pull it up. Thank you.
And 331.
And 331. Thank you.
Those aren't confidential, right?
No, it wouldn't be confidential.
Brian, you're unmuted.
This is the correct page. Whoever's in charge of this, if you could, Michelle, if you could scroll down, I want to pick up beginning at line 14. Okay, we can see that. If you could bring 14, go on, scroll down on that page so it brings up the next page. That's fine, right there. That's good. That's good. So this brings up lines 14 through 25 on page 330. And in particular, for this purpose, lines 1 and 2 on page 331. Hopefully you can follow what we've done here, Mr. Vetch. My object is not to confuse you in this question. All right. We start with line 14. Here's the question that's asked of Mr. Allen, the lead engineer for the Southwest Power Pool. The question is, all right, we have had testimony by various witnesses concerning a parallel 161 kV line parallel to the proposed route here that is currently in existence and being operated by Evergy. It is roughly 25 miles in length. Did the processes within SPP in considering the award of this particular bid take into consideration this parallel line and its implications? And Mr. Allen's answer is, again, to the extent that there were feasibility concerns, we would take that into consideration. But in the case of proposing new greenfield transmission, we don't typically consider the existing right-of-way of transmission that gets into the routing concerns. The SPP, now on over to page 131. The SPP doesn't say the, so the SPP does not do routing studies. Do not do detailed analysis to that effect. That's the end of the pertinent part I wanted to have quoted here. Now, with, again, Brian, with your assistance, bear with me. If you could pull up from the transcript pages 381 and 382. With respect to page 381, beginning on line 12. Yes. Okay. And let's see. We'll take these one at a time. Okay, Mr. Vetch, I would draw your attention to, again, this is the transcript of Mr. Kelsey Allen, the SPP lead engineer. It's his testimony at the evidentiary hearing on cross-examination. And if we go down to line 12 on page 381, which is before us, yes, thank you for marking it. I'm asking in pertinent part, the question is, the problem as I see it here is that there's 25 miles of an existing Evergy 161 kV transmission line that is likely to be parallel to this Wolf Creek Blackberry line if we approve it. Now, Mr. Vetch, I want to skip from there down to line 20. Where on the far right hand side it begins with but. But my concern is we've had testimony over the course of the last day and a half that doing this, in the event we approve this CNN and the siting that's subsequent, could entail some really consequential costs. So my question to you is, comma, why are there such matters as this, comma, and existing? Now on down to page 382, please. That's fine. Continuing, I'm going to repeat that sentence beginning on line 24 on 381 and continuing on 382. So my question to you is, why were such matters as this, an existing, and I repeat it again, an existing transmission line of consequence, not a part of this extensive vetting process within SPP, such that we might have to go through a project scope process that could entail a lot of potential funding requirements. And we're doing this all after the fact of the NTC. I mean, does this suggest that there may be something about the vetting process here that needs refinement so that big ticket items like this don't become issues this late in the process? Again, for the record, Mr. Allen's response to that question, beginning on line 10 and going through line 15, is this. That's a good question. I think I would answer that by saying that, again, SPP does not do line routing. So to the extent that the proposed route parallels directly that 161 line, that is not something that we could have known or considered. We do not do detailed routing studies, period. Again, Mr. Vetch, for the record, have I read correctly the excerpts from the transcript that I've tried to read in all instances?
Yeah, yes, I believe you have.
Okay, thank you. My reason for doing this is simply this, and I'd like to have you respond to my conclusion. I'm concerned that the SPP, you're concerned about whether or not they contemplated within conjunction of within the parameters of the RFP. But what I'm concerned about is that they didn't contemplate the issues having to do with co-located lines, because their review processes did not really consider or elicit any kind of input from the KCC that perhaps could have made them aware that the potential for parallel lines could become an issue. Is that a fair conclusion in your opinion?
Yes.
Thank you. I apologize to you for taking so long to reach that conclusion, but I appreciate, again, the candor of your response. Given the preferred NextEra route of the proposed Wolf Creek to Blackberry transmission line that's set out in the routing study and the environmental report that NextEra commissioned, my question is this: without using double circuiting, what steps can be taken by Evergy and NextEra to mitigate the effects on landowners of having two parallel transmission lines across their properties along that 25-mile stretch where there would likely be two parallel lines?
Okay, I just want to make sure I understand the question, Commissioner. Is the question what can NextEra and Evergy collaborate on to minimize the impact of two potential lines running parallel to each other across 25.2 miles of the project here?
That's a fair question, but collaboration would be helpful. But what steps could either of you take, either individually or collectively, to mitigate the concerns in the event that there are two parallel lines?
Yeah, I think one of the things that jumps out to me that we could certainly continue to discuss with NextEra is access easements. How, and certainly if the right of ways abut each other, how we would plan to and where we would plan to access what now would be one larger easement, assuming that there's not any space between the two easements. In the event that there is damage to either one or two lines, a mechanism of which we communicate with NextEra on how and when, and maybe even who is accessing which properties, so that we are aware of what they're doing, they are aware of what we may be doing, and that we are not, in essence, doubling up on the amount of traffic that may be going, in, out of, and through potentially this one potentially much wider corridor.
Very good. Well, as I indicated in conjunction with Mr. Mayor's testimony, so too I will with your testimony here. I appreciate the granularity of the answer. I very much appreciate the frankness and granularity of that. Michelle, you may take down the screen share if you wish. I want to conclude my cross-examination, Mr. Vetch, with, in fairness to you and to NextEra and to the process that we're going through here in our deliberations, ask of you basically very similar questions that I asked of Mr. Mayor's. In your negotiations with NextEra regarding the proposed double circuit option, what in your view were the major points of difference? That is, matters that you found most difficult to reconcile?
I don't know, Commissioner, if we had issues that were contentious or extremely difficult. I think, as I stated in my earlier testimony, the use for us of davit arms and their use of brace post insulation as means of attaching the conductor to the pole are a fundamental difference, right? And each of those designs puts a different force, impact, strain on the pole. They use both steel and concrete as they're planning to do in this line. But I think generally, if we had differences that have yet to be resolved, it's around the use of davit arms for us and I-string insulation in both brace post insulators in the NextEra design. And I don't think that we can't get to a conclusion there. I just don't think the pole engineering is evolved yet for anyone to fully understand exactly what the implications would be.
Well, again, I appreciate the granularity of your answer. I think we're all confronted from time to time with learning curve effects, are we not? I mean, it's part of the process of life. And I appreciate very much that response. Let me ask this of you. If a pole construction standard could be resolved between yourself and NextEra, such that double circuiting could be utilized, would this not conceivably if your lines were on the same poles as their lines, wouldn't this double circuiting expedite the current times, Evergy's plans to replace their older wooden poles and allow Evergy and the NextEra to both share in the costs attendant to those double circuit poles? And in the case of Evergy, save Evergy ratepayers the cost of having Evergy at some subsequent date cover the entire cost of replacing their wooden poles at Evergy's expense.
Yeah, so there's a lot in the questions there. So I'll start with what I think was the first question. It's if we could agree on a design. In the co-location report, Commissioner, we did have two two options that were laid out there. They were built to the Evergy standard, one in a standalone right of way, in one or one in a new right of way, and one in our existing footprint. So there is, collaboration and agreement on what we could and can do. I think if there's still something yet to be known, it's can we agree or come to a conclusion on attaching our conductor to NextEra's standards. So that is, I think we've been vetting that here a little bit in the last maybe 30 minutes or so. So I'll answer that. And then can you repeat for me the second part of your question?
Yes, and my apologies. I think it's the fact that you're an engineer and I'm not that is causing me to let by being a lawyer interfere and giving you these incredibly long questions. So I apologize for that. Yes, I'd be happy to ask, but I think you're driving at as the second part of my question. My question is, wouldn't it be in Evergy's interest to engage in this double circuiting from the perspective of basically allowing both companies to share in the costs of constructing a single line sufficient to accommodate your two different sets of lines? And in the process, wouldn't it also benefit not only Evergy, but Evergy's ratepayers? Because it would, at least for the purpose of that 22 miles, that's all I'm talking about. I'm talking about the complete redo of your entire line, but I'm talking for that 25-mile interval. If wouldn't it save really Evergy and Evergy ratepayers the latter or subsequent expense of having to go through and have Evergy replace those poles at your sole expense? That was the second question.
So the question, as I understand it, Commissioner, is wouldn't it be more economical for Kansas customers if the NextEra and Evergy co-located on the same structures? The co-location report says that it wouldn't, that it would actually be more costly. And again, getting into what we haven't quite solved yet is if we can put our conductor or our davit arms on a concrete pole, that design hasn't yet been established. We don't know what the incremental cost may or may not be there. And then, also the cost allocation mechanism of having our local pole on a regionally allocated pole certainly adds additional layer of complexity here as to proving, who's causing what costs out there, and invites, potential issues down the road. So I don't know if I got all the way to the end of answering your question, but that's I think my answer.
I think if I were to distill it in terms of what I think I understand you to say, and I want you to correct me if you think my understanding is wrong, is that what you're saying is there are a whole series of trade-offs that are involved, and there are complexities that are involved in this process because it's an unusual circumstance. It's a novel circumstance. And I think, as Mr. Mayers indicated yesterday, he didn't know a single instance in the United States where you had two different utilities co-locating on the same lines. My take on that, quite frankly, I'll give you my take in a nutshell, but you can certainly discard it. You're free to do so at will. Mine is that I'm glad that Edison didn't have that same approach in undertaking all the inventions he's brought to making our lives comfortable today. So I think because it hasn't been done before doesn't mean we can't make a shot at it here, and we can't even pioneer this. So what I'm concerned here too, Mr. Bench, and I think we share this concern. I think we share, and I believe NextEra shares the concern. We're trying to really balance all these interests of the affected landowners with the utilities' ability to deliver efficient and sufficient service in conjunction with their missions. I think that's what we're trying to do, and that's what I'm concerned about here, and that's why I think that some of these issues having to do with double circuiting are worth, no pun intended, are worth taking to ground. I mean, I think we just really need to ferret them out and consider the thing seriously. I would invite any observations you would have about my thoughts there.
Yeah, I would agree with you that we're trying to strike a balance here as we do in our approach to building any transmission line. And there are trade-offs in almost everything that we do. And it's a difficult path. And that's why, we have hearings such as this, so we can talk about these things and get all the best ideas kind of up on the table and make the best decision collectively for all parties going forward. But yeah, certainly we are attempting to strike a balance.
Mr. Vetch, I sincerely appreciate your testimony. I appreciate your candor. I appreciate the granularity of your responses. That concludes the public non-confidential questions I have. I have some of those that I'll reserve for a later time, but thank you, sir, so much for your testimony.
Thank you, sir.
Thank you, Commissioner Keen. Turning to Commissioner French, do you have questions at this time?
Yeah, I thought I would only have confidential competitive questions, but I think Commissioner Keen's line of questioning has helped me identify a couple of questions. I do have a lot of questions about why the SPP independent panel identified the solution it did or didn't identify a double circuit solution. But I think most of that we're going to have to reserve for a confidential session. But I think I can ask a few general questions. If I don't know that we need to pull it up, but Commissioner Keen was asking you about page 6 of your February 21st direct testimony. And I think it was in that testimony that you identified one of the practical downsides of sort of moving down this path of instead of moving forward with the current proposal, but instead requiring Evergy and NextEra to pursue further coordination on a double circuited line together. Would be your opinion that would cause restudy at SPP of the project, likely rebidding the project for new competitive solicitations, and the fact that could take, I'm trying to recall, I think it was your opinion was a sort of a minimum of 1 year, but probably much longer of delay. And and you ran through the list of the downsides to that, the lost economic benefit to ratepayers, the loss of operational flexibility, and the lost reliability benefits as we push out the in-service date of these facilities. And that's all well taken. I guess I'd like you to, if you're unable to answer this question, I will understand, but I'll ask you to think hard about it. If the commission were to go down the path of asking NextEra and Evergy, I suppose denying the permit for the time being and saying, look, go back and only bring us something back that co-locates the double circuit. And you start to move toward restudy and resubmission of bids at the Southwest Power Pool. What assurance do we have that if this is restudied and rebid, that SPP, the jurisdictional planner, would ultimately come back with a different solution than what they've approved here? I mean, is it possible they would just approve the same solution? Do you think it's likely they would? Do we even have any assurance in 2 or 3 years that they'll come back and give us the solution that we're asking Evergy and NextEra to pursue, hypothetically?
Yeah, Commissioner, I cannot opine or give any testimony as to what the Southwest Power Pool expert panel may or may not do in the future, considerations they may or may not make. I'm not, close enough to that panel or the board to determine how they may view this in the future. Should they be presented with a different set of circumstances, or maybe even the exact same set of circumstances that got us to this point?
Well, that's a totally fair answer, and I suspected it might be your answer, but I thought it was worth a try to ask. I did. Let me move to one other question. I thought Commissioner Keen asked you a good question about, okay, if supposing we do approve the proposed route, subject to some modifications, and there is a section that is co-located, he asked a question about, well, what mechanisms could you put into place to minimize disruptions to landowners? And I don't, maybe this is in testimony somewhere, but I don't recall seeing it. You mentioned that there could be some mechanism for Evergy and NextEra to coordinate with one another to, for things like maintenance, or if there's an outage to get in. I guess what I'm envisioning that being, I've kind of changed it in my mind to some sort of coordination agreement to minimize impact on landowners. Could you just elaborate on what you were describing there and exactly how you view that sort of helping out landowners in that area? Maybe it's a general proposition and it needs to be fleshed out further, but I thought it was an interesting idea.
Yeah, I don't know of any legal precedents or exactly how we might go about accomplishing that, Commissioner. We certainly will have an operation agreement with NextEra on the operation of the line, right? So we'll be discussing with them at some point how we go about operating the line, and potentially on the surface trying to think about how do we collaborate here with NextEra to minimize the potential impacts to landowners. So, I think inviting the discussion, having the discussion may lead to us being able to do that. I don't know if at this point that's possible or not, but I think finding out is something that collectively we should aspire to.
So I don't want to put words in your mouth, but it sounds like you were saying it would be reasonable for the commission to require Evergy and NextEra to enter a coordinated operating agreement that minimizes impact on landowners along the co-located portion of the route, and to file that with the commission, perhaps with some explanation of how it would minimize disruption to landowners.
Yeah, I don't know if I would agree with saying we must, more that we should absolutely have the conversation and ascertain if we can. And if we can, what that would entail.
All right. One final question, just for clarification. I actually, this is pretty important to me, as I sit on the regional state committee at the Southwest Power Pool, and we don't plan transmission, but we do have authority over cost allocation. And I'm very aware of the different mechanisms for how different types of facilities are cost allocated. And you brought up cost allocation and the complexity of that. And I believe what you're referring to is the fact that the NextEra line would be what we call a highway facility, which is cost allocated across the entire footprint. And the Evergy line, because it's a 161 kV line, would be a byway facility, which is allocated 2/3 to the local Evergy zone and 1/3 to the region. So they have different cost allocation. And as I understood it, what you were saying is there's basically no precedent for those types of facilities being combined, and there may not even be a cost allocation mechanism where the Southwest Power Pool could cost allocate the costs of a single facility that has two different voltage levels on it. Is that what you were getting at?
Yes. Yeah, it will become another added layer of complexity that would needed to be vetted and solved.
Okay, I think I'll leave it there. I think any other questions I have, we'll have to delve into confidential competitive information, and so I'll leave my questioning there. Thank you, Mr. Vetch.
Thank you, sir.
Thank you, Commissioner French. Yes, I have some questions. Mr. Vetch, do you view NextEra as a competitor in the state of Kansas in your region?
No, I mean, we both submitted a response to SPP's RFP, and for reasons I may not be fully aware of, NextEra was chosen to build this line. Our task here, and as ordered by the commission, was to assist in that endeavor, and that is what we are doing. So yeah, for this line, the point of being a competitor is past, so I don't see them as being a competitor on this project, not anymore.
Okay, but overall, beyond this project, do they bid on other things that in your territory?
I don't know the extent of what NextEra is either doing or not doing, in our territory or elsewhere.
Okay.
Certainly when we are, competing for the same projects, we would be aware of it then, but I'm not aware of any at this point.
Okay, so you said you're not quite aware what SPP was, why NextEra was awarded the bid. Would you assume it primarily had to do with the cost of their bid proposal versus Evergy's bid proposal?
I don't know the weight that the independent panel or the board at SPP gave to cost on the selection criteria relative to all of the other criteria, so I can't answer that.
So should I assume it had to do with pole structure?
I cannot answer that question.
Okay. Does Evergy ever adjust their pole standards that they use? This current H pole is a wood pole, right, for the 161 line?
Yes.
So in your replacement, I think you said you would not be replacing it with wood. What would you be going back with?
We would go back with a steel monopole.
Okay. Do you ever use concrete poles in Evergy territory?
We had a pilot in Wichita in the 70s. So very dated and very rare for us, but it has been done. It's the only line that I'm aware of in our service territory that was constructed with concrete poles or spun concrete poles. And that line is not in service any longer.
Okay. NextEra has made some assertions that they are like the largest transmission provider in the United States. Do you agree that they have a certain level of expertise regarding this type of line that is the matter of which we're speaking?
Commissioner, can you repeat your question, please?
So NextEra's, I think in their documents have shared that they're big throughout the 42 states. And I don't know how many thousands of transmission lines. Would you agree that they are a leader in the development and construction of transmission lines throughout the United States?
I wouldn't opine or go so far as to say a leader. I think they've certainly demonstrated their capability to build transmission lines.
does Evergy have doubt at all about the worthiness of their concrete poles, or does it really have to do with the arms design?
Yeah, we don't take issue with the material used to build the transmission line. Our concerns are, if asked or even ordered to attach our conductors to a pole, that they are conducted to a pole that would meet our standards and use our hardware.
And it's your standards concerning a 345 or the 161 kV?
Yeah, so for us in this instance, we would be potentially attaching our 161 line to the same poles that NextEra's 345 line would be attached to. So having a structure that could accommodate both circuits, and ours being attached via a davit arm.
Okay. Where does this 161 line end? Where is this terminus point?
Has several terminus points. I believe I may bring up a map if that's all right with you.
Yes, please.
And I'm not sure if I need to share my screen or not. I think I can describe it all right.
Okay.
So our line begins at the Marmonton substation, just between Ellsmore and Moran, Kansas. The first segment runs south and east to the Jayhawk switching station. Beyond that, it goes to our Franklin substation, which is primarily responsible for serving Pittsburgh area. And then beyond that, it goes to Litchfield, and then beyond that, a tie with the Empire or Liberty.
So it ties into the Liberty line.
Yes.
Okay, and I think you did share in the report your concern about the substations, if there was co-location and any additional work that would have to be done. Is that correct?
I'm not sure that I'm familiar with that. And I don't know if it's just I can't recall.
Well, let me ask it this way. If you rebuilt your 161 line, just forget there's even a 345. You're just rebuilding 161. Would you be doing work on your substations there, Jayhawk, Franklin, and then there at Litchfield?
Yeah, so not at Jayhawk. That's fairly new switching station. The 345 line would not be stopping at any of these substations. It would be traversing I believe around 94 miles all the way from Wolf Creek to Blackberry without any stops along the way in any other substations. Our line certainly has in and outs at a switching station, and then the substations I had talked about, whereas the 345 line would not be doing that.
So the 161 line would, you did contemplate as you're thinking about this project of replacing 161 in 8 years or so, that it would require some substation work as well?
I cannot say for sure if the line rebuild would include substation alterations as a result of the line rebuilding. I also don't want to say that so strongly that it doesn't, because quite honestly, I'm not certain.
Okay. I think you just said that you do share on your smaller lines, that you share the poles. I mean, you double circuit on smaller voltages, is that correct?
Yeah, I don't know if I said about the voltages. So transmission lines coming into a substation certainly become more proximate to each other the closer they get to the substation. There are times when the circumstances provide for us to be able to double circuit those lines. And we certainly would take an opportunity to do that if provided such a circumstance. The voltage, I don't believe I made any indication on voltage as being a determining factor as if we would do or not do that.
So would 345 be something that you would, as you're coming into those stations, coexist on one pole?
Yeah, I would say if we are allowed to do that, we would certainly entertain the idea of it. Having two 345 structures or circuits on the same structures for a long distance is a potential additional risk to the grid, which we may not be allowed to even do. But certainly if we had an opportunity to make an argument that it was worth the risk to do so, we would have that discussion with the Southwest Power Pool.
As I believe it is in most instances, the need sometimes moves ahead of where we are in rules, regulations, and the paperwork generally follows much further behind in making adjustments to needs or adjustments to technology. I just say that as a statement. Can we talk about buffer issues? I think you suggested there be a buffer between your line and the other line. And what was the purpose of the buffer again?
So we are in the infancy of beginning to look at the rebuild of our line. We have not done the title work on the corridor to even know exactly the width on every parcel of what our easement is. We're assuming, but we don't know for certain if the current line is in the middle of the existing easement. So there's a lot of unknowns for us at this point as to what we actually have in terms of easements along the corridor of our existing line. If there are parts of our corridor that are 75 feet, which we believe there to be, but haven't again done the title work, they will almost absolutely need to be widened to 100 feet to accommodate the new construction. And if we have an abutting easement on that 75-foot corridor that we wouldn't be allowed to extend our easement that direction, we would be then forced to some extent to go the other side. The impacts of all of that and where those are is unknown at this point, but it's certainly a risk. So that in generally, if we had a buffer and we had a need to widen our easement, we would like to widen it slightly on both sides rather than making all of the adjustment on one side or the other.
Okay, so you're saying that when you were doing the rebuild, these adjustments would need to take place at that time?
Yes.
Okay, so I guess I was assuming it had something to do with if they built a new line, you wanted to make sure you had plenty of room for your rebuild. But this is beyond that. This is where there just might be small, narrow right-of-way strips.
Yeah, I would say it's a combination of all of the above, Chair Duffy.
Okay. Okay.
Having an abutted easement really limits us on what our future options may or may not be when we go to assess our easement and rebuild the line.
So there is by Evergy opposition to the abutment.
Opposition is maybe a little stronger word than I would use. I mean, we would prefer to have a buffer because it gives us future optionality on issues that we're not yet aware of. We certainly understand the landowner impacts and having, you know, a corridor of land between the two easements that is confined by the easements. I understand that. I don't prefer that. And but for the 345 line being next to ours, wouldn't be seeking it.
Okay, if you had to rebuild your 161 all by itself versus looking at a shared build on a single pole, co-locating, would Evergy's cost be more for that? And I'm not talking about the 14 million for, you know, that issue. I'm just talking about dollars spent to build a separate 161 replacement versus sharing costs on a single pole, co-locating two lines. What's more expensive?
So the co-location report that we assisted NextEra with, it says that the co-locating of the two lines is more costly than building the two lines separately. The one that would have been built in our existing easement being the more costly of the two options.
But doesn't that take into account the $14 million loss each year by the continued congestion that is on the line, not having the line?
That only took into account the construction of each lines, both separately and then together.
And what do you attribute the increase in costs to, as there would only be one pole, not two? There would be two lines. It would be a shared cost. So if you could be more specific about the increase.
Yeah, so I was not involved in the details of putting together the co-location report. I can say generally I understand what drove the additional costs, and I'm happy to share that with you here. The additional size of the structure certainly added cost, and the number of structures increased as a result of adding a second circuit to the 345 line. That also was a driver in adding additional cost to the double circuit option.
Okay, that's fair. All right, I will hold, I do believe the rest of my questions are competitive, confidential in nature, and I will hold them. At this point, everyone, we are going to...
Debbie, if I could, pardon my interruption, please. I just wonder if I could ask one follow-on question of Mr. Vetch.
Go ahead.
Thank you. I'll be brief. I was very interested in the colloquy that you had with both of my colleagues here. With respect to the colloquy you had with Commissioner French and kind of hypothesizing about whatever we do here and what the SPP reaction to it might be, if it's anything other than just absolutely granting the application pretty much in the form it's in. I would only add kind of parenthetically that we can hope calmer heads would prevail under any outcome here. But with respect to SPP, I'll speak for myself. I may believe that there are aspects of the RFP process that could benefit from an affirmative eliciting by the SPP of input from the state regulator regarding, with respect to a prospective line, any conceivable problems they may anticipate, which might, or at an early stage, ferret out the issues we're trying to cope with right here. But the fact that I might believe that, the fact that the commission might subscribe to that belief, that the fact that all the parties here might believe, doesn't really provide any assurance that in the end the SPP is going to go with it, does it? I mean, we could advance all the arguments. I would like to think that if we advance reasonable arguments for the positions we take, that they're going to be heard out. And I honestly believe that they will be. But There's no absolute guarantees here, are there?
I do not believe so.
Okay. Well, thank you for hearing out my question. Thank you for allowing the question, Chair Duffy.
Okay, you sure? Okay, it is now 11:17. We're going to take a break, reconvene at 11:30. So if everybody will mute your microphones, we'll see you at 11:30. Thank you. Okay, folks, it is 11:30. We are back on the record. Thank you. And here is my intent that we will break for lunch approximately 1 o'clock or between 1 and 1:30, and it will be a 30-minute lunch break, just FYI. So if you need to put your mayonnaise sandwich back in the fridge, please do so. All right. I'll turn next to NextEra. And I'm looking around. I don't know who is Andrew. It's you. You're
Yes,
on.
it
You're
is
on
me.
point.
And
All right.
can everyone hear me? Yes, we had a couple of questions for Mr. Vetch. Hi, Mr. Vetch. I'm Andrew Schulte, representing NETE Southwest in this proceeding. Do you have with you the co-location report that's been marked as Exhibit JB1?
I do.
Okay, and I need to turn to it myself, actually. Could you turn to page 8 of the co-location or double circuit report?
I'm there.
And this report was not prepared by Evergy, is that correct?
That is correct.
But you are familiar with it,
Yes.
and it does include information that NETE Southwest coordinated with Evergy upon.
Yes.
On page 8, I'm in section 3 and the second paragraph of section 3.
Okay.
And the second sentence of that, well, actually the whole paragraph is relevant. It states NETE Southwest also engaged extensively with Evergy to gather information and to review and analyze the double circuit option. Did I read that correctly
Yes.
with that statement from Evergy's perspective?
Yes.
The next sentence states NETE Southwest and Evergy engaged in at least 14 separate meetings to discuss items such as engineering design specifications, reliability, routing, real estate agreements and condemnation, economic impacts, landowner impacts, cost allocation, schedule, and O&M activities. Did I read that correctly?
You did.
And were you involved in those meetings referenced in that sentence?
No, I was not involved in the 14 meetings. I did stop in briefly to several of them just to understand what the tenor of the meetings was, how the discussion was going, and making certain that we were doing exactly as we had been ordered to do by the commission.
And based on that involvement and your overseeing of the process, do you believe that the discussion items that are listed there are an accurate list of the discussion items?
Are you asking me if I feel like that sentence or that second paragraph from the end is inaccurate?
Yes, I mean, are those items that are listed there that I just read, is it your understanding that those items were indeed discussed by both parties?
Yes.
I'm going to object to the question. The witness has already indicated that he has no knowledge of what went on in the meeting beyond just being superficially involved.
Mr. Kimmel, you're overruled. Continue with the line of questions.
And as it relates to the questions that the commissioners have had about whether NETE Southwest and Evergy considered landowner impacts on the double circuit option, do you agree that NETE Southwest and Evergy did in fact discuss those landowner impacts and consider them?
Yeah, the members of my team that were involved in the discussion and were present in the 14 meetings have assured me that they have covered all of the specified topics in the second to the last paragraph of page 8.
Thank you. If I could turn to page 23, please. And let me know when you're there.
I'm there.
And I'm on the second complete paragraph on that page.
How does it start, Mr. Schulte? The
NETE
paragraph?
Southwest also notes that.
I'm with you.
Okay. And the complete sentence is NETE Southwest also notes that given the extended schedule in which Evergy estimates it plans to rebuild the 161 kV line, even if the commission required the double circuit option, that would not meaningfully minimize impacts to landowners, at least not in the short term. Did I read that correctly?
You did.
Do you have any disagreement with that assessment?
I don't.
And then moving to the last sentence of that paragraph. Actually, I'm going to read the second sentence of that paragraph, sorry, as well. As explained above, NETE Southwest and Evergy would need to obtain right-of-way from all landowners along the co-located section, even if the double circuit option were built in Evergy's right-of-way, requiring NETE Southwest and Evergy to negotiate, in parentheses, and potentially condemn landowners along this segment. Did I read that correctly?
You did.
Do you have any disagreement with that statement?
I don't.
Okay, now I'm going to move to the last sentence, which states, therefore, NETE Southwest believes the landowner benefits from a double circuit option may be delayed and or minimal. Did I read that correctly?
You did.
Do you have any disagreement with that sentence?
I don't.
Okay, thank you. Commissioner Keen, and I'm finished with exhibit JB1, if you want to navigate away from that. Commissioner Keen and Commissioner French asked some questions about ways that Evergy and NETE Southwest could coordinate to minimize landowner impacts. Do you recall that line of questioning?
Yes.
And I think you mentioned, and feel free to correct me if I'm paraphrasing you incorrectly, that there could be coordination on maintenance and repairs and the sharing of access points to minimize landowner impacts if the two lines are built in parallel.
Yeah, I guess I'll further define the coordination of maintenance. I think it's more of communicating to one another what we are planning to do and when we're planning to do it. So just adding some additional context to my comments.
Okay. And do you believe that if the two separate right-of-ways were parallel to each other, that there would be the possibility of sharing access points?
Yeah, as I said in my earlier testimony, I'm not a lawyer and I don't know the legal path to arrive there. But I do believe, in the spirit of minimizing the impact of landowners, having the discussion and to figure out how we may go about doing that is something that we should do.
Okay, thank you. In addition to the coordination that you just testified about, is it Evergy's practice to work with landowners to microsite poles to avoid interference with agricultural and other uses of the land?
Can you define what NextEra means by micrositing, please, Mr. Schulte?
Sure, and feel free to give your own definition if you disagree with mine, but my understanding of microsite, as I use it in this question, is the moving of facilities after working with and talking to landowners, within the same general corridor, but moving it, within that same general corridor in order to allow, for example, a combine to pass through the edge of the property and the pole, or between two poles, or other issues like that.
Yeah, I fully understand the question, and yes, we do also microsite our poles. We would discuss with the landowners where we're planning to put the poles. If they have any indifferences to where we're putting the poles, we would certainly entertain a discussion with them and try to, again, find balance in the construction of the line that accommodates all interests.
And that process would apply to the rebuild of the 161 kV line that we've been talking about today.
Yes.
Thank you. I believe those are all my questions. And thank you for your testimony today.
You're welcome.
Thank you, Mr. Schulte. We will move to Mr. Kimmel. Do you have questions of this witness?
I have a few, Commissioner.
Please proceed.
Mr. Vetch, would you agree that, is it your understanding that under Kansas law that the people of Kansas, their homes, and their livelihoods are valid considerations when the KCC is deciding what is the best route for siting an electric transmission line?
Mr. Kimmel, I am not a lawyer. I cannot opine on any legal statute in the state.
Based on your understanding, legal or not, do you agree that in Kansas, the people of Kansas, their homes and their livelihoods are valid considerations when the KCC is deciding what is the best route for siting an electric transmission line?
Yeah, I think we take many things into consideration when we're siting a line, and the impact or proximity to residents or homeowners or land is certainly one of the things that is considered.
Is it generally a major consideration when you're siting a line? The location to homes?
Yeah, so I would say yes, we cite many lines. Some are in very, very urban areas, and it is certainly a consideration, some more rural. But in the weighting of how we would line site, the proximity to residents is very, very high, if not at the top of the list.
The next question I had relates to a question from one of the commissioners. Based on your knowledge, with the understanding that you don't have a legal background, or you're not an attorney at least, would you identify any authority that you know of for SPP to dictate how transmission lines are sited in Kansas, or those transmission lines designs in Kansas?
I'm not sure if I understand your question. Is your question, what authority does the Southwest Power Pool possess in determining lines siting or design?
No, what is your understanding of SPP's authority to dictate how transmission lines are sited in Kansas?
I'm not aware of any authority that the Southwest Power Pool has in determining line siting.
Thank you. I have no further questions, Commissioner.
Thank you, Mr. Kimmel. We will now move to IBEW. Mr. Wood, do you have questions of the witness?
Questions, Chair Duffy. Thank you.
Okay, thank you. And moving to staff, and I'm not sure, is this Mr. Latif?
Yes, thank you.
Do you have questions?
Chair Duffy. I do have a few questions. Good. I think we're still morning. Good morning, Mr. Vetch. My name is Hassan Latif. I'm an attorney for staff. I just have a few questions for clarification purposes for you. In your testimony, you mentioned that the davit arm was necessary. Could you explain a little more about why a davit arm is necessary for a double circuit line on concrete poles?
Yeah, I just for clarity on the question, I'm not testifying that it's necessary for the use on a concrete pole. It's the standard to which we build our transmission system. We believe the davit arm and the I-string insulator provides an added layer of protection in comparison to other options because it allows the conductor to flex and move in the event that it's damaged or breaks, and normally doesn't result in additional feet or miles of conductor landing on the ground.
Thank you. Also, in your testimony before, you mentioned that Evergy did have one line that had concrete poles, which is now out of service. If you know, do you know why that is now out of service?
Yeah, the reason why we began to take the poles out of service is the substation from where it terminated was expanded. So we were required to move and rebuild a portion of that line. In the process of taking those poles out of service, it was apparent that there was significant deterioration or spalling on the inside of the concrete structure. So it wasn't visible to the naked eye, but once we got the poles up out of the ground, we're able to see the kind of the internal parts of the pole. Certainly concerned us because they had degradation that we weren't aware of, and at that point became I guess less confident in the poles that were still existing, and then they at some point were also removed from service.
Okay. So that you didn't have evidence they outright failed at the time you took it down, but you did notice it when you took them out that they had degradation.
Yes.
Okay. Evergy currently does have co-ownership and cooperates a large project in that it has co-ownership of the Wolf Creek nuclear plant. Is that correct?
Yes.
And so based on the ability of Evergy to operate a nuclear plant and the complications involved with that, would you say that the operation of a 25-mile portion of one transmission line is more complicated than that or less complicated?
Is your question comparing the difficulty or complexity in operating 25 miles of transmission relative to the operational complexity of operating the Wolf Creek nuclear facility?
That is my question.
I don't work or operate the Wolf Creek nuclear facility, but I will say for the record that I believe the operation of the nuclear facility is more complex than 25 miles of transmission line.
Okay, thank you. Are you aware of any other co-ownership of projects with Evergy, either for generation or transmission, that are currently operated on between Evergy and another company?
So again, just for clarity, are you asking, am I aware of any co-ownership that Evergy has on the transmission system on the same set of structures?
No, I'm just asking for if there are other projects that Evergy operates that are where there's cooperation with another company.
I don't have knowledge of that. I just can't answer the question.
Okay. No further questions. Thank you, Mr. Bench.
Thank you, Mr. Lateef. I'll move to commissioners again, Commissioner Keen. Further questions for the witness?
No questions, thank you.
And Commissioner French?
I have no additional questions. Thank you.
All right, Evergy redirect?
Madam Chair, just briefly,
Yes.
and can you hear me okay? I'm sharing a computer.
Yes, I can.
Thank you. Mr. Vetch, there was some testimony or elicited some testimony from you regarding the circumstances where double circuiting a line or would be appropriate. And I think, tell me if I'm correct here, you've mentioned if there's proximity to a substation and then also shrinking the land footprint.
Yeah.
Okay. Was your testimony intended to address circumstances where, as here, the lines are owned or operated by different transmission owners?
No, all of the lines that we double circuit, the lines are both owned, constructed, operated and designed by Evergy. We don't have any foreign utility or transmission owners on the same structures that we are located.
There's also a line of questions about just the process, the study process, double circuit, that it culminated in that report. You remember that line of questions?
Are you referring to the double circuit report?
Yes.
Okay, yeah.
Okay. And I just want to make sure, I'll ask a few questions just to clarify. Did Evergy work collaboratively with NextEra in good faith to evaluate the double circuit option?
Yes.
Did the two utilities fully consider, study, and evaluate the double circuit option in the time?
Yes.
I don't believe any further questions. Thank you.
Okay. Thank you. I'll turn back to commissioners. Commissioner Keen.
No questions in the public section. Thank you.
Yes. Commissioner French.
Nope. Thank you.
Okay. And Mr. Vetch, you may virtually step down, but do know that we will recall you for a confidential session, okay? And you will still be under oath at that time.
Very well.
All right, very good. Okay, folks, we are going to step back to Rochelle McGee Smart. Mr. Kimmel, is she now available?
She is.
Very good. Okay, so I'm looking for her on the screen. So that
Commissioner, we're going to have to share a computer. She's here in my office.
Oh, okay. All right. Very good. Ms. Haas needs to swear her in. So if she could step forward, I would appreciate it. Very good.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter not hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you.
Okay, Mr. Kimmel, if you want to prepare your witness for cross-examination, please.
Ms. Smart, would you please state your name for the record?
Rochelle McGee Smart,
And what city do you live near?
Colony, Kansas.
Are you the same Rochelle McGee Smart who filed direct testimony on February 21st, 2023? And a March 31st, 2023 response to public comments?
Yes.
Do you have any additions or corrections to make to your testimony at this time?
No.
If I ask you the same questions today as appear in your pre-filed testimony, your answers remain the same?
Yes.
I'd move to submit the direct testimony of Rochelle McGee Smart dated February 21st, 2023, and the response to public comments dated March 31st, 2023 into the record.
Any objections? Hearing none, it's so ordered. Okay. Here we go. All right, we're going to start with commission questions. Welcome. Rochelle, I hope things went well this morning.
Thank you, Commissioner. I got one set done. We still got a long ways to go yet.
I understand. Okay. All right. So I'm going to lead off with Commissioner Keen for questions of the witness.
Thank you, Chair Duffy. Good morning, Ms. Smart.
Morning.
Nice to have you with us. I've read through your testimony in its entirety. At this point, I have no questions.
Thank you, Commissioner Keen. Commissioner French?
Similar to Commissioner Keen, I think I'll defer any questions until after the party's cross-examination. Thank you.
Very good. We will move to NextEra, and I'm not sure who's taking the lead here. Andrew Schulte.
Yes. NEAT Southwest does not have any cross-examination questions for Ms. McGee-Smart.
Thank you, Mr. Schulte. And Evergy?
No questions.
Okay. Thank you very much. Ms. Caper, moving to IBEW, questions of this witness.
No questions. Thank you.
Thank you, Mr. Wood. And staff. Mr. Lateef, questions of the witness.
No questions, Chair.
Thank you. Heading back to commissioners, Commissioner Keen.
No questions. As I say, I've read through all of your testimony, both in this and in the prior docket, and I just don't have any questions.
Very good. And Commissioner French.
Yes, same as Commissioner Keen. I fully reviewed the testimony, and I thought maybe the parties would elicit some additional questions, but since there's no questioning, I don't have any questions. So thank you.
And I would adopt Commissioner French's statement there as well. So Ms. McGee-Smart, I guess you can step down and return to your most important work there, and good luck to you this afternoon.
Thank you.
Thank you.
Chairman, would you please confirm that you did grant my motion to admit her testimony?
If I forgot to do that, I do admit the testimony that was offered. Yes.
Thank you.
All right. Very good. All right, folks. Well, it's high noon. I thought this witness would go a little bit further. Is there any objections to breaking for lunch before our last witness? All right, it's 12 o'clock. We'll see everybody at 12:30. And remember to mute your microphones, and see you then. Thank you all. Okay, folks, everybody back? Thank you. All right, I'm looking for Commissioner King. There he is. Okay, great. All right, we're going to proceed then, and we're back on the record and proceed with our next witness, Leo Hanos. Mr. Hanos, are you available? There he is. Okay, very good. And Ms. Haas, if you will swear a witness in, please.
Okay. Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay, I'm looking at staff. Mr. Latif, is this your witness?
It is my witness. Thank you.
Yes, if you would, please continue.
Good afternoon, Mr. Hanos. Would you please state your name and business address for the record?
My name is Leo M. Hanos. My business address is 1500 Southwest Arrowhead Drive, Topeka, Kansas.
By whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission as the Chief Engineer of the Utilities Division.
And how long have you been employed by the commission?
I've been employed for a little over 24 years with the commission.
And for those 24 years, you've worked in utility regulation on behalf of the commission?
Yes, I have.
In total, you have the 41 years of engineering background?
That's correct.
Are you the same Leo Hanos that caused to be filed in this docket on February 21st, 2023, direct testimony containing 31 pages of questions and answers and 5 attachments?
Yes, I am.
And you authored several versions of that testimony, I believe. There was a public version, a confidential competitive version, confidential competitive NextEra version, confidential competitive Evergy version, and a confidential amended testimony that was filed on February 23rd. Those were all the testimonies that versions of the testimony that you filed, is that correct?
Yes, they are.
Additionally, on March 31st, 2023, you caused to be filed in this docket staff's response to public comments consisting of 20 pages of questions and answers and one attachment. Is that correct?
Yes, it is.
Do you have any additions, revisions, or corrections to make to your testimony at this time?
Yes, I have some corrections and also a couple of additions I'd like to address. On my direct testimony, I'm going on the public version as far as the name or the numbering system goes. On page 20 of my direct testimony, on line 1, the sentence says calculated minimum clearance would need to be 33.5 feet. I wish to change that to say the calculated minimum clearance would need to be 29 feet 3 inches. And similarly, on line 3 of that same page 20, the line 3 would say minimum clearance over cultivated land would be 31 feet 3 inches. And also,
Mr. Hanos, could I ask you to speak up or maybe you get closer to your mic?
okay, we'll see what we can do here.
Microphone. Thank you.
If you give me just a second, I'm afraid I'm going to pull the power cord off the mic. So let me go move something here in just a second.
Should we just move the table forward?
Yeah. Okay, let's try that. And if I have to readjust, I'll do so again. Okay.
Thank you.
Shall I start with my changes that I was discussing, Denise?
Let's see, the last one was starting on line 3 of the same page 20.
Starting on line 3 of the same page 20, I would like to change the notation that says 33.5 feet to say 31 feet 3 inches. And along with those two changes, I would delete my footnote 31 on page 20. And this change is due to one of the many conversations we have with NextEra, and they pointed out an error I'd made in this calculation. And I'm going to defer to their calculation after they show me how to do it correctly. The other change I'd make is on page 22. It's a reference there. It's exhibit LMH4, but the change I'm making is actually on the exhibit itself. And on exhibit LMH4, it's a series of data request responses that relate to land restoration and construction practices. When I prepared this list, I left 3 responses in there which really aren't relevant to restoration and construction practices. So I would ask those to be deleted. And those are numbered KCC number 3, number 4, and number 6. And then if I may, I'd like to add some additions to my testimony that are really about what was discussed this morning. I think it would help. This morning we talked about the costs of some of the recommendations that I've made in my testimony, and I would like to have on the record that the costs that may be impacted by my recommendations are fully recognized in NextEra's bid, and they're discussed in staff's report and recommendation in the 22419 docket on pages 12 and 13. And also, I would ask that if the commission accepts the proposed route, I would recommend the commission adopt the microsighting options that are discussed in data request 42 to be modifications of the proposed route. So they would be part of the proposed route. And that DR 42 was entered into evidence. Those changes, I think I've done.
Other than those corrections, if I were to ask you the same questions today that are contained in your testimony, would the answers be the same?
Yes, they would.
Chair Duffy.
I would like to lodge an objection with regard to the DR 42 reroutes as being recommended by the commission as the route to be approved in this case. First of all, that's additional direct testimony that was not available until just now, which is after our witnesses have already testified. So there's no opportunity to provide rebuttal testimony with regard to that recommendation. So that, if that was staff's position, then it should have been made into the record prior to our witnesses being testified and excused from the proceeding so that we could have addressed it. There's also, it's also a confusing recommendation since there are some of the potential reroutes include multiple alternatives. So I'm not sure what the actual recommendation from staff is at this point. And it's the first time we've heard this recommendation.
Mr. Latif, do you want to respond?
Yeah, the DR 42 was responded to after the timing for testimony was made in this docket. We asked questions about that DR to NextEra witnesses during this, and Mr. Haynes is available to ask questions of. To the extent that NextEra opposes us asking for that recommendation, I'd say that they have the opportunity to question Mr. Haynos now, and that the commission is free to decide whether to adopt those routes in their recommendation or not.
Okay. I would like the commissioners to go into a breakout room, please.
Just to be clear, the concern we have is not resolved by the opportunity to cross-examine. There should also be an opportunity for rebuttal testimony from witnesses of NETE Southwest. And I'm afraid at this point in the proceeding, there's just not time to do that.
Okay. Thank you, Mr. Schulte. Commissioners and General Counsel to the breakout room. Thank you. There we go. All right. Okay. We'll wait for Commissioner King. There he is. Okay, very good. We are going to sustain the objection. We allow for the corrections to the testimony, but not the additional reference to additional testimony. No. So the objection is sustained. Staff, you're on mute.
Is that just the additional testimony with regard to DR 42?
Any additional testimony, we are allowing the corrections that Mr. Hanos introduced to his existing testimony.
Okay. With that, staff would ask for Mr. Hanos's versions of direct testimony and attachments, as well as staff's response to public comments, be incorporated into the record in this docket.
Any objections? It's admitted. Okay. All right, here we go with commissioner questions, and we will start with Commissioner Keen.
Thank you, Chair Duffy. Good afternoon, Leo.
Good afternoon.
Leo, have you been able to listen in on all of the proceedings thus far in this evidentiary hearing?
Yes, I think I have. I may have missed a little bit, but very little of it.
Okay. Let's first consider your take on the double circuit option. And in that regard, your recommendations. So Michelle, if you could, I would appreciate it if you could do a screen share on page 29 of Leo's direct pre-filed testimony dated February 21st, 2023. I think David may have provided it. That's good. Great job. Thank you. Scroll down just a bit, if you would, to where recommendations is kind of at the heading right there. That's fine for now. We'll move on in just a moment. As I say, this is page 29 of Leo Hanos's pre-filed direct testimony dated February 21st, 2023. Leo, your first recommendation, excuse me, appears to be captured on lines 12 and 13. And for the record, and for the benefit of the court reporter, I'll read that in. Beginning on line 12, it's a number 1. And then after that, it reads, I recommend the commission consider the double circuit option jointly operated by 2 utilities to be an unreasonable alternative. That's the entire quote from recommendation number 1. Leo, did I read this correctly?
Yes, you did.
Here's my question to you, Leo. In light of the record developed in this matter thus far, including the evidence and cross-examination testimony for all witnesses preceding you, is there anything that would cause you to reconsider in any respect this option, this recommendation?
No, there is not.
All right. If you would, Michelle, scroll down to number 3 so it's fully captured on the screen. That's fine. Thank you. Can you see that, Leo?
Yes, I can.
Let's take a look at your recommendation number 3. And again, for the benefit of the record, I will read it in. It reads, beginning on lines 18 through 20, number 3. And then the recommendation is, I recommend the commission consider approaching SPP to allow states the opportunity to participate in developing routing parameters to include in a request for proposal any future competitively bid transmission lines. That's the end of the quote I'm seeking to have in the record. Leo, have I correctly again read what is this recommendation?
Yes, you have.
All right. What I want to ask you is, and for the time being, Michelle, you may take down the screen share, but have it ready to come back, please. What I'm headed toward here, Leo, is having you share with us what is it that prompted this recommendation, and if you would expand upon and further explain what you were suggesting or recommending that the SPP do to revise its procedures to take into account state regulatory concerns when bidding competitive transmission lines.
Well, when you see the RFP that was sent out by SPP, they just list the two endpoints of the line, the Wolf Creek substation and the Blackberry substation. They provide a map that shows a direct path between the two, which kind of implies that it would be a straight line, but that's not what they have in their bid at all. It's a competitively bid operation. That means costs are going to be a driver in this decision. As a matter of fact, from what I've read of FERC 1000, on the FERC 1000 order, that's the very purpose for the FERC 1000 process, is to get the cost of transmission down. The shortest route of the cheapest line is going to be the shortest route, and that's usually going to be a straight line unless there's some sort of obstacles in the way. And that's the bid that came in probably from NextEra and others as well, I would assume. We were, from that process, SPP issued a notice to construct without really the KCC being involved in any steps up to that point after they evaluated the bid. And NextEra came to the KCC with a notice to construct that stated, here's the bid that won, and this is what we've granted the notice to build. And given that directive, we evaluated NextEra for a certificate of convenience, a CCN, to make them a public utility in Kansas, underneath the whole premise that the NTC was the very definition of NextEra being a utility in Kansas. And then we go into a routing proceeding. So we're being forced into a set of constraints that we can't really get out of very easily. There's only a couple of options if reading the tariff from SPP, and that is that the commission could change the route and say, no, we don't accept that one. And NextEra could either accept that result or reject the NTC, the notice to construct. The project would then go back to SPP and we would start this whole bid process over. And as you recall, in the 22419 docket, when we discussed the benefits of this line, it's clearly evident that it serves a purpose to reduce congestion and lower pricing for Kansas, especially in Southeast Kansas. To set that off farther because of this process, again, puts a constraint on the commission that, to take a position that does not approve the route as it's given to you or presented to you would be economically detrimental to Kansas. And it starts to limit your options as far as to balance your concerns between the landowners and the utility interests of the state. I think that more or less wraps it up as a summary.
Well, so basically, what is it you're suggesting by way of a recommendation? I'll be gentle, that the commission make to the Southwest Power Pool.
I think the commission needs to address Southwest Power Pool to, I think it's not just Kansas, by the way. I think it's every state that has routing. If we are part of that process and we look at the public interest effects, and I say that in more in line with the landowners and the counties, do we want diagonal lines through Kansas? Do we want lines that are set back off of roads? How should we have a routing study or a model be used for, designing the study or screening the study? What are the principles that should be used? All those steps, if they're built into an RFP, then every company that's bidding on that has the opportunity to perform a bid that can address our concerns or the commission's concerns early on. Without doing that, what you can end up doing is boxing out the other utilities that bid on this project, because you only have one alternative in front of you. It's either up or down on the proposed route. And you can do that. You have total authority to do that. But a vote to not approve the proposed route would cause further economic costs to the state of Kansas that could have been totally avoided if these terms had been in the bid in the first place.
I think that's a very articulate summary of my concerns, to be very honest. Are you suggesting, and I'm going to push the envelope a little further, Leo, are you suggesting here that it would be beneficial if the Southwest Power Pool would consider, for all purposes, prospectively, affirmatively and directly eliciting input from the affected states and the state regulator, input about any kinds of concerns or complications or unique facets or features about that may impact the practical implementation of the notice to construct if the RFP is suggested. Am I close?
Yes, you are.
I commend you very much for this recommendation. I think I think the dilemma we have, and I think you articulated it, I'll probably say it in a way you might want to disassociate yourself from, but for me, what that doesn't get us off the hook in the present case, because it's the absence of this of eliciting our input that I think has contributed mightily to putting us in this really incredible situation here. And I'll let it go at that for the time being. Let's make an assumption for my next question that the commission approves having basically 2 lines cited, accepts the proposal in the main that's being advanced here by NextEra and its citing docket. So with respect to this 22 or 25 mile portion of this line where the landowners are going to be faced with these parallel high voltage lines, how can this matter be, if we don't do double circuiting, how can this matter be mitigated? I mean, how can the effect on landowners be mitigated? I would throw out a couple of hypotheticals. I don't endorse them by throwing them out. I'm just trying to turn the rock as much as I can to explore this, because I think they have some downsides to them. Stair stepping. I actually addressed that with one of the NextEra witnesses, using public rights of way in lieu of crossing over either diagonally or otherwise private lands. So in your opinion, please, what other mitigation steps or actions could be taken or reasonably undertaken to protect private property rights and landowner rights?
I'm not sure, Commissioner Keen. At the first part of your question, were you restricting this type of question to only the piece that's the double, where the 2 lines are parallel to each other, or to the entire line?
I would say to the entire line. Thank you, Leo, for that. To the entire line, but with some particular emphasis on the unique facets of the problem we confront with respect to that 22 or 25 mile portion. Both questions. Yeah.
And I think Mr. Worth addressed some of this. There are considerations that you could look at. And in fact, if you look at some of the and I have this in my testimony as well, some of the unregulated generator tie lines, they do quite a bit of stair stepping. because it's just an unpopular option when you should put in diagonal lines across people's property. So you'll see very little, at least at the ones that we reviewed, the longer ones, where they don't have eminent domain authority, where they actually run a diagonal line. It is more of a stair step. That's an option. That means a lot more expensive line. You're going to have a lot of turning structures. You have a lot longer line, and you're going to impact more landowners. So those are the trade-offs that you have to deal with. A straighter line is a shorter line, and it probably means in the long run, less landowners are impacted. So that's number one. It becomes a policy decision for Kansas. Does Kansas want to see this type of development? And I say that not only because of the NextEra line, but also looking to the future. With electrification as it's building in this country, you're going to have a lot more electric transmission lines being built in Kansas. So to get this right, how you want this to develop is similar to building streets inside a city. It's almost a zoning question, right? Except it's on a much broader scale. And that's why it's really necessary to understand exactly how you want this to be. So I think that it's a discussion that we should have. Should these lines be more of in the cardinal directions? It seems in the last few lines we've developed, that I put in my testimony, that is how we built them. That's just from us looking at a map and trying to pick out the sections that were diagonal. Landowners certainly do not like diagonal lines. And I would say that not only from the people that were affected by this line, but in any discussions that I've had over the years, that diagonal lines are not preferred by landowners. And in your function to balance your decision with the impact on landowners, I think that's an appropriate thing to look at as a policy decision. With respect to the two lines that are next to each other, it is as you read through the comments, which I paraphrased in my testimony on public comments, you'll see what the landowners think of that option. They just see it as more imposition onto their property. So that's a consideration for the landowners that are affected. The cost on farming operations, I just couldn't quantify that. I understand their complexities, but I could not come up with a cost to show how that would do that. You can drive out there and drive around. You'll see that these farmers have obstacles out in their fields now that they are able to navigate. This would be additional items to navigate. And I think if you give the landowners flexibility, in other words, you don't tie them into where they have to accept the result as it's offered by the company, but give them some flexibility in negotiating that, they could solve some of this. In other words, micrositing is a great tool. That's what we're addressing in DR 42 earlier a little bit. And also, distance between the lines. Some farmers that I talked to did not really want the two transmission corridors to abut each other because they said it was going to make too much of a obstacle course in trying to figure out how to maneuver this equipment between poles that are close together. Meaning close together in a width sense, not a length sense, if you think of the corridor. And they saw that as actually detrimental to their particular operation. Others thought they really need more room. So I think giving them the flexibility, but give the landowner the primacy, if you will, to make that decision.
Well, again, thank you for the granular answer. You have highlighted several rather evocative, thought-provoking issues here that I think deserve and need consideration. I think you did so in a very articulate fashion. Let me talk about something more provincial. Let's talk about polls here for just a second. We've had some discussion of that back and forth with both NextEra and Evergy representatives. So let me ask you this: from among the different recognized, approved, or accepted transmission pole construction alternatives, if it's based on the upon substantial evidence, does the KCC have within the purview of its regulatory authority in the public interest to direct the selection or utilization of a specific transmission pole construction alternative?
I think we do. You know, as you know, in the past, I'm not an attorney, but I take liberal steps toward interpreting laws, as we all do with this profession, right? Because it blends so carefully into the legal side. But I think 66-101H would give you that authority to look at the construction practices of a utility, to consider what evidence is out there. Admittedly, I don't have a lot of problem with probably newer concrete poles. I think I'm kind of intrigued by the innovation of using those in Kansas. At the same time, I'm alarmed, right, from Mr. Vetch's testimony that said, you know, when we pulled one of those out and started taking it apart, we found out the steel inside the pole that you couldn't tell from the outside was corroding. So I'm immediately thinking, well, how can you monitor that steel for corrosion? Are there ways of doing that? So there are ways to try to anticipate failures, but as far as just the types of poles, they've been used, they have a track history. I would just say that you'd want to try to understand that better. And hopefully you understand it better before you have a failure. The same with dead-end structures crossing highways. When I've talked to utilities that have had that experience, one in the recent past, that in Western Kansas, and I brought up the fact, should you install dead-end structures? Now that, you know, you saw that this didn't work because the line was laying across the road. Their answer was, it would be almost impossible to retrofit a dead-end structure underneath this line, to pour that concrete and work underneath this line to raise this structure without putting it off to the outside of the corridor and rerouting the line. That was their opinion to me on that proposal. So again, to retrofit something of that nature is going to make it much more difficult. And it'd be the same for concrete poles. If you put those in without a monitoring system and find out that, in fact, that was a bad idea and they are failing, it's going to really be expensive. And at that time, it won't be a bid. It'll just be straight rate base.
I wished I had had the presence of mind or your testimony to be able to posit that question about the monitoring. My guess is there's probably some way to do it today. Whether it exists or not, it's supposition on my part, and so I'll leave it at that. Okay. Leo, I believe that within the record that's been developed in this and in the prior CCN proceeding, we can certainly gain, I think, some insight into the SBP rationale and approach to giving, and I'm trying to be fair here, but I'm trying to be candid, deferential and preferential attention to regional rather than local concerns when evaluating competitively bid transmission line proposals. So in this regard, I want to note for the record in this docket, two matters from the record of the prior and companion docket involving NextEra, and that's that CCN docket. I'll note it again for the record. It's docket number 22-NETE-419-COC. I think we can refresh everyone's recollection that at the outset of these proceedings, the commission has taken administrative notice in toto of that docket. Excuse me.
Drop off.
Some things can't be helped. Sorry about that.
Okay.
Okay, I took care of that phone call. From the prior docket, I want to really specifically refer to a couple of things. So if, Michelle, if you could do a screen share first, we're going to Mr. Kelsey Allen's pre-filed testimony in the prior docket dated May 17, 2022, page 8.
What document again?
Okay, you may have to have David's help here. It's the pre-filed direct testimony.
There it is.
There it is. Thank you.
Okay,
Nice
I
job.
think David got it, so.
Okay. Well, I appreciate the indulgence of both of you and your assistance as well. Except now I can't, there, that's better. That's better. What I want to focus on here rather specifically are lines 8 through 13. 8 through 13. And I'll read in the pertinent part that I want into the record. And it reads as follows, beginning on line 8. And I quote, as the RTO, comma, SPP is responsible for preparing long-range plans, providing a roadmap for future transmission reinforcements that address a wide range of needs within its region. This requires that SPP's transmission planning process be regionally focused rather than locally focused. SPP's current planning process is designed such that the long-term vision for the region is determined and then utilized to inform SPP's shorter-term plans. That's the end of the quote I'm taking from here. And then you can take that screen share down if you would. And let's move to it may take Brian's help too on this. I want to go back to the transcript of the prior proceedings. We'll start on page 327.
David's working on it. If you can give him a second, he's the one who's got these documents.
Certainly, thank you. Well, we have a formidable documentary record combining the two of these, so I appreciate their help and indulgence. That is the page. In fact, if you could scroll down to toward the end of the page for me, please. And then for the record, so we all have some reference point with respect to what this is. This is, again, this is the cross-examination testimony of Mr. Kelsey Allen. He's the lead engineer for the Southwest Power Pool, as he testified in conjunction with the CCN proceedings that preceded this. What I would like to do first is let's go down to the question that's asked of Mr. Allen that begins on line 24. Actually, if we could scroll on a bit further, right there. Let's see if that won't. Well, bear with me, Michelle. We'll try to do this as best we can. Begins on line 24. The question is, my question to you is, what is your definition of locally or locally focused? What is it, in other words, you consider to be so local as to be excluded from consideration by the SPP process. And then if we, I think we've captured it here, actually, scroll up just slightly, just one line. That's fine. If we go down to his answer is, and I want to go down to the pertinent part of his answer, which begins on line 8 and runs through line 14. So the pertinent part on line 8 is, we do not get into, I'm quoting for the record now, beginning on line 8. We do not get into specific issues to the extent that facilities are under the SPP tariff. Typically, that's 69 kV and above. To the extent that there are issues that are local in that regard and are isolated, we do address those. But as the RTO, we are looking for more holistic solutions that can answer a multitude of needs, if that is what is called for. All right. Now, if you would, Michelle, bear with me. Let's go next to page 329. And you scroll halfway down a little bit more. That's fine. That's fine right there. And what I want to draw attention to here is that part of the question to Mr. Allen that begins on line 12 and runs through line 18. And I'll read it into the record beginning on line 12. It reads as follows: for all the processes of review and vetting that these kinds of projects go through within SPP, at what point is any consideration given to the agricultural, commercial, petroleum production, recreational, or other land uses of the property through which these lines might be placed? And Mr. Allen's answer beginning on page 19 through 25 is as follows, and I'll read it into the record. The answer, it's A, okay, yeah. SPP does not consider the route. And during the construction of specific transmission, we're looking at what are the best electrical connections to the system in order to resolve the issues that we foresee. We do not consider, as a general practice, specific issues in terms of land use and the other items that you mentioned. That's the end of that quote. We're almost finished. If we could next turn to page 373. Scroll down toward the bottom of the page, if you would, Michelle. That's fine, thank you. If we look at lines 20 through 25 at the end of this page, the question is, so if I understand your response then, basically in terms of ratepayers are in a situation similar to all of us as citizens in this republic, in the sense that we're represented. We have a representative government. By analogy here, the interests of ratepayers are represented indirectly. Scroll on down, please, to the next page. Thank you. Thank you. Through various proxies who have a Kansas connection. Is that a fair statement? The answer by Mr. Allen is that that's fair. You can take the screen share down now if you would. My only reason for harassing us and putting us through that ordeal was to basically try to point out that based upon the testimony of SPP's key critical lead engineer witness, technical witness, there is an acknowledgement, I think, here of the limitations of what the current system allows in terms of consideration of local issues. I'm not trying to gratuitously criticize the SPP at all. I just think there's a process here, and I don't mean to beat this into plowshares, that we can make suggestions to refine, and it might be helpful in a somewhat holistic way. And so I'm guessing, Leo, that that is, again, from another direction, in part what it is that you're trying to address within the purview of your recommendation number 3.
Yes, it is. To me, I'm not an SPP expert. I'll say that up front. But the integrated transmission plan is about the market. And when Mr. Kelsey made the one statement that you read to us that SPP does not get into routing, I disagree with him on a FERC 1000 project, because when he awarded that bid, which is totally based on the route, because they couldn't put together a monetary bid without having a route. When he did that, he got into the routing. So whether they think they are or not, I think that's the issue, right? Their scope is really economic, and he's right, and they do a fantastic job at that. But because of that, there's no bright line between the two. He's gone into the routing side, and the same you would say on the whole idea about highway, byway, and zonal costs. You know, there's no bright line between those two either, but they're established because of the policy there, and that affects the holistic value of a double circuit option, for example.
Thank you again for your response, Liam. I appreciate it very much. I just have a few more questions in the public's part of this for you, and then I'll be finished. Let's move from the double circuit issue to other recommendations that you're advancing. And once again, Michelle, if you'd be kind enough, please put up, once again, for our benefit, page 29, it'll bleed into page 30. This is from Leo's pre-filed direct testimony, again, dated February 21st, 2023.
I have page 29, but not 30.
This is
so
good.
I got
If you would scroll, you're doing a great job here, and thank you for that, all you're doing, Michelle. Scroll to where we can see all of recommendation 4 as it continues from the bottom of 29 into 30.
I don't have page 30, so maybe David Cohen does.
Okay, if you could find that then. Thank you, David.
Okay.
Is that what you needed, Commissioner Keen?
I thought they were still looking for page 30.
No, we've got it on there. He's got 29 and 30.
Okay,
And
scroll,
30.
Michelle, to where we have, we can see the bottom of page 4 and the top of page, the bottom of page 29, and there, that's close. Thank you. Okay. Let me read into the record, Leo, your recommendation number 4 begins on line 21. It's lines 21 and 22 on page 29, and lines 1 and 2 on page 30 of your pre-filed direct testimony. And it reads as follows: 4, and then it's the quote is for FOR. Denise, the future transmission line siting dockets. I recommend the commission consider requiring a route model study similar to the one presented in this docket. As a precondition to the line siting docket, I further recommend the commission establish routing principles and weighting factors to be used in the routing study. And that's the end of the excerpt and the end of recommendation number 4. You may take down the screen share now, please. Leo, I'd ask you an analogous question with respect to number 4, as I did with recommendation number 3. Give us your thoughts about the benefits that you're thinking that might be obtained by taking a really pretty holistic approach to anticipating and planning for future transmission issues.
Okay. The routing study that Burns and McDonnell did is trying to balance all the factors that are out there, you know, economic, engineering, social. The thing that they did that, in my opinion, although industry was involved, they did it in a regulatory vacuum. They did not include any input from the KCC or other regulatory bodies as to picking the factors and assigning the weighting factors. They do have feedback from various agencies and from counties as to that they were crossing through. But as far as how they assign those factors, no regulatory bodies are involved in making those assignments. And if you, for example, change some weighting factors just because it is totally within the purview of the commission to do that, to take a look and say, you know, we really don't, for example, we don't think we should have 2 transmission lines next to each other because it's just not something we want to see in Kansas. And even though Mr. Worth said that's a practice that's throughout the industry and they all somehow, without a lot of evidence, support that approach, if you took that factor and just weighted it to something less, you know, from what I can't remember what it was, 8 or something, it was fairly near the top, it would change this whole route. And it would take the whole proposed route and you start over. And it would start over all the way back to the NTC more than likely, because the risk would be on NextEra to build something they had no chance to evaluate at the same bid price. So if they return the NTC, which is totally in their authority to do, and it's contemplated in the open access transmission tariff of SPP, then we start the whole process over because the route would be totally different. So again, it's a similar situation that you see with SPP. You're locked into an up or down vote.
Leo, how do you see this recommendation dovetailing, intersecting, or interacting with current SPP line siting approval processes? How do you see that interaction?
The current SPP process?
Or perspective that you'd recommend?
So if the SPP agreed or with input from other states, agreed that they would consider routing principles put out by the state, I would use this Burns and Mack study actually for an example. I think it's a good study. I would take those principles and have the commission decide on those. So I think it comes to that level, by the way, decide on what principles we will be using. And then those principles have to be developed into somehow incorporated into the RFP that SPP would put out.
Absolutely. Well, as I suspect you can surmise, I'm deeply concerned about the adequacy and the thoroughness, really, of the SPP evaluation and review process for this competitively bid transmission line and prospectively for others. I'm also concerned about, and I think we share this, about the lack of direct state regulatory involvement, preferably being elicited within the purview of a more structured approach in the process of the RFP process, and certainly in the interest of trying to give us the opportunity to provide input that will protect all the various stakeholders in Kansas. Thank you so much, Leo. I appreciate so much your answers, and I appreciate as well your indulgence of my questions. I have no further questions, Chair Duffy, of Leo Hanos in the public session.
Thank you, Commissioner King. Commissioner French.
Thanks. Just a couple of questions, Mr. Hanos, and I know I have some confidential competitive items, and I'll certainly leave those to our confidential session. I want to pick up on just that very last line of questioning with Commissioner Keen, because I have the same question about how we would dovetail this into future SPP processes, and obviously, you know, we would be trying to work with them and negotiate something with them for them to amend their tariff, I think, to accommodate this. But you don't need to turn to it. But as I understand it, if you look at attachment Y of the SPP tariff, and it's also included in the independent expert panel report, they lay out within the tariff what the metrics are that panel has to use to judge the bids that come into them. And as you're thinking that there could be a section within those metrics that accounts for each individual state's routing metrics or input that it's given for routing considerations, that would be looked at depending on which state the project was located in, that those would be laid out within the metrics, and that the bidders would all know that they need to account for those metrics when they supply a bid.
Yes, sir. I think that's the right way to go. I don't know how much specificity each state would have to give, but you would certainly want to give enough that you wouldn't find this situation coming up before you again. Some states may be more willing to put a lot of data in there. We heard from Mr. Worth that there are states that do that. I'm not surprised at the two states that he mentioned, but I don't know what terms how they actually do the process. And I don't know how well they operate with their RTO either. If this situation could be the same dilemma that they would face through a FERC 1000 order.
Thank you. I appreciate that testimony. It's very helpful for me. The only other item I wanted to address with you, I think Commissioner Keen had a line of questioning on, where our authority may lie in requiring certain types of poles or structures. And you had a back and forth about concrete poles. And I don't so much have the question about concrete poles, but I do want to talk to you briefly about your recommendations on eliminating the guide structures where landowners prefer to have unguided structures, and your recommendation for NextEra to add the dead end structures. I'm going to give a preface here that I share your liberal interpretation of our ability to add conditions to a siting permit where it's in the public interest. Qualified as any attorney would, that any of our decisions have to be non-arbitrary, reasonable, supported by substantial competent evidence, of course. And I will say that is what I'm struggling with a little bit, is what we are relying on for those particular recommendations. I certainly understand them from a safety standpoint, that they would be desirable, but I'm trying to get a bit more context of why you recommended them, because as I understand it, neither of those items would be required under the wire stringing rules or regulations that the KCC has set, and which apply to all of our utilities, regulated and unregulated. So we couldn't require those of any other entity, even though some might voluntarily choose to do it. I guess I'm struggling a bit with why it would be reasonable for us to require something in this permit that we could not require and may not require of other entities in the state. I think you did give one additional piece of information, which is that you have a concern that if we don't require it now, it would be difficult to retrofit. But maybe if, I just wanted to give you the opportunity to expand because I'm struggling of what is it that's unique about this project that why we would want to why it would be reasonable for us to require these things that go beyond our wire stringing rules when we maybe don't require it of other entities.
Okay. Well, first of all, I'd say I'm not a transmission line engineer. And I see the processes that they put forward. And I would say that all those meet sound engineering judgment and they're used throughout the country, you know, and across the world. So the idea of using guidelines doesn't make it less safe than using you know, self-supporting structures for turning structures. And the possibility of lines falling across a road are probably there. You know, there's probably some chances even with dead-end structures, the line can fall across the road. You minimize it perhaps more. So with that in mind, the other part of my job, as I see it in this particular proceeding, is trying to balance the interests of the public that have to deal with these lines in picking this route. And I've talked to a lot of farmers, and I can't tell you one that likes guide structures in their fields. I had one guy tell me that he would rather have the line closer to his home than to have deadline structures in his expletive pasture. It wasn't his row crop, it was his pasture. They don't like them. And that's why I didn't, in my testimony, I didn't say that you should just eliminate them. I said you should give the farmer a choice. You know, in other words, if you don't give him a choice through an order, though, the choice is eminent domain, whichever the utility wants, as long as it's within the route. So if you put that opportunity for him to negotiate as a possibility in the order, then it becomes a little different. So this is really about balance of the considerations of the utility and of the homeowners, and also looking at the costs. I think that's a consideration that has to be raised as well. On the dead-end structures, we heard earlier that you know, they agreed to put those across transmission lines with Evergy. Not that that has any difference than across a road. The roads we're talking about, you know, the bigger ones, 69 and 169, they move over 1,000 trucks a day. I've spoken with DOT to try to get their feelings on this. They don't have regulations, that's correct, and that was pointed out by Mr. Mayers. They don't have a regulation that requires it. Talking with the engineer for KDOT, they told me on the phone that yeah, the bridges that would be around the area where these lines would be crossed could not support truck or semi-truck, and probably couldn't even allow them to navigate on some of the roads in the immediate vicinity of where the line would cross. So you would have traffic backed up for a considerable amount of time. Is this something that's insurmountable? I don't think so. NextEra, although they haven't filed their emergency plan with us yet, that's part of the 22419 requirements, I think. We'll have a contractor making these emergency repairs. The contractor may have other jobs going on because when you have a storm event, usually they're busy. So unless he's on retainer, you may not get the response you think you're going to get, which means that line stays across the road longer. And so in the end, I guess what I'm looking at on the dead-end structures is the point that, you know, if we can afford this resiliency request to Evergy so that we don't have a power outage that affects hundreds of thousands of customers probably, we ought to be able to afford the resiliency approach, or the elimination or reduction of a potential threat, which is what resiliency is. We ought to be able to afford that same effect to public safety. And in that case, the line across the road. And as you mentioned, retrofitting is probably really not an option.
Well, I appreciate the answer. I certainly don't think I tossed you a softball there, but I appreciate all of the additional thinking on that. It is helpful. I don't believe I have any more public session questions unless something comes up through the additional cross-examination. So thank you.
Thank you, Commissioner French. Good afternoon, Leo. Just briefly, and this is a very hypothetical situation, of course, but had Evergy won this bid with SPP, would we be having all of this discussion about poles and guy wires and line paths as well?
Yes.
It would be the same discussion. The commission would have had the same authority to weigh in as we are weighing in now with NextEra, correct?
What we would have had with Evergy winning a bid from a FERC 1000 project would be a project presented to you that's a notice of construct and a path that you have to either accept or deny the bid, basically. Because that's what happens if you deny the proposal, is that the bid more than likely could not go forward with the price, because they've designed the bid to fit the price that's in the bid fits a route. If you change that route dramatically or completely change the route, it's going to totally affect that cost. And unless you pick a better route and it's cheaper, the company would have the right to reject the NTC, to reject the notice to construct, and it would go back to SPP.
Right, but all the discussions surrounding the ultimate path, all the, whether they're using steel or concrete or guy wires or dead ends, that would all occur as well.
I think it could, it very well could, as far as the type of material they're using. And we've done this before. To be candid, this is the first greenfield line sighting routing I've been involved in. We don't do a whole lot of them. The last two were Evergy Westar projects, and they were, built back into the same path of an existing transmission line. Even then, we had a lot of discussions. We had a study, I think, by Burns and McDonnell at both of those that looked at a lot of different routes to make sure that the existing route was, in fact, still the best route. And it came to the conclusion that it was. Out in the field with them, we did microsighting, trying to move poles out of backyards and take into consideration, if the line had to be moved over slightly from the original path, how to figure that part out. So there were a lot of considerations, and it was a joint effort to come up with a solution, but it wasn't the solution as presented to us.
Okay. Concerning this line or this project, you and your staff have spent a lot of time talking with landowners and farmers. Is that correct?
Yes, a lot of time. We've talked to a lot of farmers.
Did you spend some time also, quote, driving the line as best you could?
Yes, we did. When we went out there for the public hearings, we drove, I think on the day between two, we drove all day long looking at different parts of the line and trying to take, pull up maps and try to see where we were and how this was going to affect, where the crossings were as best we could determine them, who was going to be affected, try to get a visual on what the impact would look like. So we drove a lot of it, but certainly not all of it by any means.
So you've been very active participant in this discussion, in this project discussion.
Yes, I have.
Okay. All right. Yeah, that's all the questions I have for the public portion as well. So we will next move to NextEra for questions. Mr. Schulte.
Thank you, Commissioner Duff, or thank you, Chair Duffy. Do have a couple of questions for Mr. Haynos. Good afternoon, Mr. Haynos.
Good afternoon, Mr. Schulte.
You were the staff witness responsible for engineering issues in the certificate of convenience and necessity case involving Wolf Creek to Blackberry. Is that accurate?
It is.
And are you aware that staff entered into a non-unanimous stipulation and agreement along with several other parties, Evergy, Curb, Kepco, Sunflower, and NETE Southwest in that case?
Yes, I am.
I'm going to share my screen here if I'm able. Hopefully this works. Let me know if you can see the document that I've shown here.
I can see it.
We're going to scroll to the top of the attachment, which is the non-unanimous settlement agreement in docket number 22 in NETE 419-COC. Do you see that caption and title?
Yes, I do.
And is this does this appear to be the non-unanimous settlement agreement that I just referred to?
It appears to be. I haven't read it in a while, but it looks like it's right.
Okay. I'm going to scroll down to the terms of the settlement agreement. In paragraph 10A, there's a term that states the settling parties agree that NETE Southwest should be granted a CCN pursuant to KSA 66-131 to transact business as a transmission-only public utility in Kansas and to construct, own, operate, and maintain the project as described in its application. Do you see that settlement term? And sorry, I didn't hear the response.
No, I do.
Okay, thank you. And would you agree that the concrete poles were a part of the project as described in the application in the CCN proceeding?
I believe they were listed in there. They're definitely within the bid documents we reviewed.
Okay, thank you. I'm going to stop sharing. Regarding the poles that were installed by Evergy in a pilot program in the 1970s, are you aware of what type of construction was used for those concrete poles?
The first I heard of those was in this proceeding, at least that I recall, and the first I ever heard of them failing was also in this proceeding.
Okay, but you're not aware if they were cast in place concrete or spun concrete?
I've not heard that, no. I'm not aware of it either way.
Okay. Do you agree, regarding the recommendations number 3 and 4 in your pre-file testimony? And that's the recommendation for, well, let's pull them up to make sure that I'm not misstating them. Because they're on page 29 and 30. I think we can avoid sharing the screen because the screen was shared earlier by Commissioner Keene. But number 3 is recommending that the commission consider approaching SPP to allow states the opportunity to participate in developing routing parameters to include in a request for proposal for any future competitively bid transmission lines. Is that an accurate reading of recommendation number 3?
Yes, it is.
And number 4 is for future transmission line siting dockets. I recommend the commission consider a route model study similar to the one presented in this docket. As a precondition to the line siting docket, I further recommend the commission establish routing principles and weighting factors to be used in the routing study. Is that an accurate reading of your recommendation number 4?
Yes, it is.
Do you agree that further proceedings are required, including the establishment of a generic docket or a rulemaking proceeding with notice to all potentially interested stakeholders in order to accomplish those recommendations, number 3 and number 4?
I think that's the route to go. As much as I really don't want to start another general investigation, but I think that's probably where you have to go.
Okay, so your recommendation is not that the commission should establish an approach with SPP or standard routing principles in this docket?
Not in this particular docket. The commissioner has the duty to approve a route. If the route was not acceptable to NextEra and they went back to a new bid, if they rejected the NTC, then I think the commission should, in any future one, certainly get involved.
Okay, I appreciate that clarification. Those are all, well, let me check with co-counsel real quickly here. Okay, those were all the questions that we had. Thank you.
Okay, thank you, Mr. Schulte. Mr. Kimmel, do you have substantial questions for this witness?
I do, Commissioner.
Okay, it's 1:50, and I'm thinking maybe we take a 10-minute break, or actually it's 1:52, come back about 2:00. No, let's come back at 2:05, and then we'll start with your questioning, Mr. Kimmel.
Okay.
Okay, all right, thank you.
Thank you.
Okay, are we all here? Commissioner Keen is with us and Commissioner French. Thank you. And Mr. Kimmel, I believe Leo Haynes is your witness.
Thank you, Chair.
To cross-examine. Yes.
Thank you, Chairwoman. Good afternoon, Mr. Haynes.
Good afternoon.
I'm going to, if it's okay with you, I'm going to shut off the video while I question you because of hopefully that'll improve my internet connection. We've had some problems in the past. Would that be okay with you?
That's fine with me.
Mr. Haynes, do you agree that the law in Kansas on transmission line siting is not simply about the shortest distance between 2 points, and it's not simply about the least expensive route?
I do. I mean, if you look at the, here I am, an attorney giving an attorney advice, or not an attorney giving attorney advice. But I will say that if you look at the statute, it asks the commission to balance 2 or 3 factors there. I don't have it in front of me, but it's not about just.
He's always interpreting statutes and.
I'm sorry, I'm not sure if there was.
I think Ms. Caper.
overlap talking.
Yeah, your microphone was on. If we can just make sure the microphones are off. Thank you.
I'm sorry, Mr. Kimball, did you get my answer?
Have we lost Mr. Kimmel?
I don't see him, sure.
Okay, why don't we just pause here and just see if he comes back in. Whoever is admitting folks, look for Mr. Kimmel to be coming back in.
Yeah, I'm watching for him. Hopefully he realized he dropped his connection.
We're trying to call him and also email him to let him know that we have lost the connection.
Hello, this is Rustin Kimmel calling in.
We hear you, Mr. Kimmel. We knew we had lost you. Good. Okay. If you want to continue on, that will work.
I appreciate that, Chairman.
Okay.
Chairwoman. Mr. Haynos, I'm not sure that I don't think that I heard the end of your response to my first question. So I'll restate that again, and hopefully I didn't miss too much of it. But the question I posed was, do you agree that the law in Kansas on transmission line siting is not simply about the shortest distance between 2 points and is not simply about the least expensive route?
Yes, and my answer, Mr. Kimmel, was that although I'm not an attorney, as I read the law, it gives several factors that the commission has to balance in reaching a decision on the correct route.
And would you agree that under the Kansas law of siting, that in Kansas, the people of Kansas, their homes and their livelihoods are valid considerations when the KCC is deciding what is in the best interest for siting an electric transmission line?
Those are some of the factors that have to be considered.
you agree that in fact the KCC initially, that the KCC proposed co-location of 25 miles of transmission line originally?
I'm sorry, Mr. Kimball, I think I missed part of that.
Would you agree that the KCC staff originally proposed co-location, that KCC staff proposed co-location of 25 miles of transmission line in this docket?
No, we did not propose it. We recommended that the commission ask the parties that would, the utilities that would be involved to study that option and to present a study to the commission.
Would you agree that the farmers and ranchers along that 25-mile stretch of co-located line are already hosting a high voltage transmission line? And that any KCC order that required a second 25-mile taking for a second high voltage transmission line would be a hardship for farmers and ranchers along this 25-mile stretch?
There would be a second line placed on their property if the commission approves the proposed route without the double circuit. It would, in the view of the many landowners that I spoke with along that line, be considered a hardship. However, I was not able to quantify economically what that hardship would be. I think there are some valuable concepts or abstract positions, and I've tried to list those in my testimony responding to landowner comments.
Well, I guess, would it be fair to say that that hardship would include a loss of productive farming and ranching land, and also a personal and family hardship for the families that have worked this Kansas land for several generations?
So your first question, would it damage the farmland or inhibit it? I think it does to an extent. It certainly will change their practices for operating a row crop operation, for example. Big equipment has a hard time getting around structures. It's just going to become much more difficult for them. Not much more, but it'll become more difficult, I should say. The second part of the question, I'm sorry, could you repeat that, please?
That hardship includes a personal and family hardship for those families that have worked the Kansas land for several generations.
So in the context of what do you mean? Just I don't mean to be flippant, but the sentimental value of this, because it's going to change their life if you have another line. Yes, it will change how it impacts the line, as it does for any line that's built. Impact the landowner.
Would you agree that you changed your recommendation for siting the transmission line? And you've now recommended 25 miles of parallel high voltage line because Evergy objected to the co-location, and Evergy and NextEra contended that co-location would increase the cost of the transmission line?
No, I have not recommended a route. I've left that up to the commission. What I've said in my testimony, in my opinion, is the route is reasonable, and it may be one of many routes that are reasonable, but I've not recommended a route. As far as the double circuit line, I did recommend not doing the double circuit line, partly because of the costs, which are not that much of a difference, not because of the complexities of trying to navigate this. The double circuit, in my opinion, the idea of a double circuit for transmission lines is something that should be looked at. It's almost impossible to do that in 90 days, as we found out.
Would you agree that Evergy and NextEra are recommending through the parallel high voltage line that farmers and ranchers further restrict their decades-long farming and ranching operations for a second time? And be such
excuse me, I have an objection. The questions that Mr. Kimmel is posing misstates the evidence before the commission regarding NEAT Southwest position.
My response, I don't believe that it's misstating the evidence, but Mr. Schulte can address the issue on, or another witness can address this question at a later point. This, hello?
Yeah,
Hello.
are you there, Mr. Kimmel? I was just, you want to complete your response?
I'm not misstating. I don't know what he's saying that I've misstated the record about. And furthermore, I guess he can address it on recross if he wants to do that. But it's simply not a misstatement of the record.
I believe what Mr. Kimmel stated was that Evergy and NEAT Southwest position is that they will further burden the farmers and landowners of Kansas.
I asked the witness if he would agree. That's what the question was. I asked the witness whether he agreed.
I'm going to deny the objection. If the witness doesn't agree, he can say so. All right, continue, Mr. Kimmel.
Would you agree that Evergy and NextEra are recommending, through their parallel lines, are recommending that farmers and ranchers further restrict their decades-long farming and ranching operations for a second time and be subject to taking of their land for the alleged purpose of relieving transmission line congestion so that customers in Missouri, or as SPP says, points east, can save a few pennies on the wholesale cost of electric energy?
No, I do not agree with that statement.
What portion do you not agree with?
Several portions. I'd have to break it down for a little bit. I'll try to remember where you had it. I don't agree with the portion that this is about, I think, sending power, or SPP sending power to Missouri. I don't agree with that. I don't agree that NextEra and Evergy are recommending that this be done in order to restrict or somehow harm landowners. Those two for starters. I think I've probably missed a couple in there, but I could start there. And if you have any others you want to point out, I'll try to answer those as well.
You will agree with me, however, I think that you did agree that the parallel lines will further restrict farming and ranching operations, correct?
They will. Not only the parallel line, but any new construction. It's a green space line, so any new construction is going to restrict the land that it crosses. That's why a siting proceeding is so critical to a line siting.
Would you agree that to some observers, perhaps many observers, that a KCC order that takes land for a 25-mile parallel high-voltage transmission line would be viewed as putting Missouri urban interests for a bit lower price above the interests of the farming and ranching communities in Kansas?
I believe that statement's inaccurate. I don't believe, first of all, that it's even a consideration that we're trying to, or the proposed project is trying to put landowners at a disadvantage. The fact of the matter is, an electric transmission line needs to be built. And this proceeding is about trying to determine where to build that line. What's the best route to have the least impact is the best way to say that. on landowners, because there will be affected landowners, whether it is along this route, whether it's along a parallel line, where there are two lines, or there's a double circuit. There will be affected landowners when you have to build a transmission line.
If these Kansas and farmers and ranchers are ordered by KCC to host a second parallel high voltage transmission line on their property, provide a small financial gain for customers in Missouri, would you agree that?
I object to the argumentative nature of these questions. They are not based on any testimony that's been filed in this case. They're simply statements of Mr. Kimmel's arguments.
I don't believe it's, I don't understand what he's talking about as being argumentative. This, Commissioner, I'm asking the witness if the Kansas farmers and ranchers are ordered by the KCC to host a parallel high voltage transmission line, which was what would happen in this case.
The question was also laced with Mr. Kimmel's arguments regarding the necessity for the line, which is not, I mean, it's his argument. It's not anything that's based on Mr. Hanos's testimony.
I'm going to reaffirm what I said earlier and overrule the objection. If the witness disagrees, the witness can disagree.
I'll start over, Mr. Hanos. If these Kansas farmers and ranchers are ordered by the KCC to host a second parallel high voltage transmission line on their property to provide a small financial gain for customers in Missouri, would you agree that perhaps many observers in this docket would view such KCC order as an extremely disrespectful to the agricultural community in Kansas and to family farming and ranching operations along this 25-mile stretch of land?
I don't believe it's a disrespectful approach to this. I don't, there's several parts of your statement that I don't agree with about the cost to Missouri for one of those, or the benefit to Missouri. Again, any route will have an impact on affected landowners. There's no doubt about that. And that's the reason for these proceedings, is to try to pick the best route to minimize that impact, but it will not eliminate the impact. There will be impact. What we're trying to do is understand what is the best route.
I'm asking you, I appreciate that response, Mr. Hanos. But I think that the answer does not address my question. Do you believe that observers of this docket, perhaps many of those observers, would view a KCC order as extremely disrespectful to the agricultural community in Kansas?
Well, you're asking me to speculate on that, to see if they would view it as disrespectful. I think the landowners that I've spoken to, and I don't even know how many that is, but it's a lot, would be disappointed if this line is placed on their property. There's no doubt about that. As if we change this route and didn't follow a secondary transmission line, didn't have a diagonal line, it would be a whole nother subset of landowners that would be disappointed if this line was placed across their property. That in fact is, I think, what you're asking me. Would people be disappointed if this was placed on their property? And the answer is yes, it would be. But the line has been shown to be necessary in the KCC staff's view by the 22419 docket. And the necessary line is going to be built, and it's going to impact landowners.
Let's talk about that impact on landowners. Have you measured the loss of farming and agricultural land in Kansas of the 2 parallel high voltage transmission lines, each with a 150-foot easement, the total easement of 300 feet? Let me put it this way, 300 feet, the length of a football field that extends 25 miles.
I'm sorry, do you say they had the loss of use of that land?
Have you measured the, right, have you measured the loss of farming and agricultural land associated with?
The actual loss of land that would be available to farming would be the structures that are placed in the land. They would still be able to farm underneath these lines for the most part. There will be some obstructions, I think, around poles to just maneuver equipment, which will increase a little bit more than just the structure. Will it change farming operations? You know, I think there was a question earlier from Chair Duffy about did we go out and drive along these lines? And we were out there during the fallow season, so there wasn't a lot of, there's no crops that were, you know, coming up, but you could tell where corn and soybean have been planted. There's a lot of transmission lines out there in this part of Kansas. And as you drive along, you can see that people are farming underneath these lines. Now, I'm sure it's more complicated to farm underneath these lines, but people have adjusted to this over the, I think Mr. Vesh said these lines were built, the one that's out there now was built in the 60s. They certainly have adjusted to farming underneath that line. Will it have an impact? Yes, because it's a second line. Will it minimize what they can do between the two lines? Certainly. They couldn't build a structure there for sure. But as far as the ground that's being farmed now, they could still farm.
Would you agree that there are other possible transmission line routes that do not require 25 miles of parallel electric transmission line?
I tried to look at that after Mr. Worth's testimony just the other day, and it appeared that based on the spreadsheet, this is in our data request, response to data request 23, that in fact, there would still be almost 20 miles of length of line that's going to be along the transmission line across the whole 90 mile transmission line. So the routes presented, I'm not sure I can answer that effectively. It looks like it won't be this one stretch that we're all talking about, the Evergy 161 kV line. But as they get closer to the substations, they are running parallel to some lines, at least by the report we looked at from Mr. Worth.
And what report would that be?
It's Mr. Worth's testimony. The DW1, it's exhibit DW1, it's the routing study.
And we'll and you're referring to DW2 as well, that has all the maps associated with that routing study. Is that what you're referring to?
I may be. I mean, I looked at a spreadsheet that listed all the various routes, the 729 routes, and in one of the columns in the spreadsheet, they will list the amount of line not along a transmission line. And if you look at the total length versus that number, you can get a feel for how much in fact is along a transmission line. And just doing that simple math, and that may be too simple for the model, by the way, but just doing that simple math, most of these routes at some place are going to be parallel to transmission or close to transmission. I don't know how close they'll be. This particular one, we were definitely talking about abutting right-of-ways, but there may be others that they consider to be nearly the same way. I don't know that for sure. But as you get toward the two substations, there's a lot of activity with the various lines that are coming into the substations. And I'm sure that's where they're picking up mileage on both ends of the line.
If the KCC orders a 25-mile parallel high voltage transmission line in this docket, would you be willing to go with me and meet with the farmers and ranchers along this 25-mile stretch in their living rooms and explain to them why such KCC order is reasonable?
I'm going to object to this question as being argumentative and non-relevant.
Mr. Kimmel, I am going to sustain the objection here. Can you continue on with your line of questioning?
I didn't I didn't know I didn't catch the legal basis for the objection.
But it was argumentative and wasn't relevant to this, what we have to consider in this proceeding.
Mr. Hanos, do you believe that there are that there are other less social and economic damaging options available as compared to the line presented by NextEra?
I think if you look at the routing study and you adjust the weighting factors, other routes would come up. There's no doubt about that. The routing study, as it was pointed out yesterday, and it's a little different than the way I was considering it, to be honest, is more of a screening tool than an actual, in fact, an actual model that they would apply. Right or wrong, I think that's how it was used to eliminate or to get it down to a handful of routes to consider, rather than trying to hard fit or hard code a route. But if you consider the fact that if it was being used to hard code a route just by tweaking some numbers and seeing what comes out, when you make those changes, it changes the route. And as I pointed out, I think it's the purview of the commission to decide what that weight should be. In this case, they've been made. Their approach to doing this, although I don't understand all the ramifications and certainly wasn't part of the meetings where they NextEra and its consultants came up with these factors. Their approach is a reasonable method to apply it. So with that being said, my recommendation, actually, I don't think I even recommended this, but I found in my opinion that it is a reasonable route.
Well, let's talk about the routing study for just a little bit to address that issue. In your testimony in response to public comments, you refer to the cardinal direction of particular routes. You recall that?
Yes, I do.
And that routes 1 through 5 generally run north and south and east and west?
Yes.
I'm going to refer you to what's referred to that I've previously submitted as McGee Exhibit 16.
I don't have that here in front of me. Do we have Exhibit 16? I can't.
I didn't catch that. Did you?
Is there a way Michelle can pull it up? I don't have it here on my computer that I'm using.
Hopefully they.
We're looking to see if we can find it. Hold on. David is going to put it up on the screen. Mr. Kimmel.
Thank you. Mr. Hanos, can you see McGee Exhibit 16?
It looks like, yes, I can see it now.
And that's essentially 2 tables. Do you see that? Make sure
Yes,
that we're talking. Since I'm on the phone, I want to make sure that we're looking at the same thing. So it's 2 tables?
Yes.
And you indicated previously that you watched or you otherwise observed most of the prior testimony. Did you observe Dusty Worth's testimony regarding these tables?
I did follow that, yes.
And you may recall that Mr. Worth agreed that the numbers presented in these tables for 1 through 5, routes 1 through 5 and 65 were correct summaries of those numbers that appear in Appendix A and Appendix B of his testimony.
I remember Mr. Worth had some disagreement with this, but I don't recall what it was. I believe that you're correct. The first 6 rows, he agreed had been copied from one of his attachments or appendices inside his testimony.
And I guess in regards to the social and economic impact of this line, there's been a lot of discussion about how that if you run north and south, that the lines are going to be coming close to residences. Do you recall that?
I do.
And if you look at routes 1 through 5, they have a lower residential proximity score as compared to the selected route. You would agree with me? Or excuse me, not the selected route. Route 65.
I agree, Mr. Kimball, and actually, I think I point that out in my testimony as well.
Okay.
That question, could Mr. Kimball repeat that question? I think you cut out, Mr. Kimball, when you were asking that last question.
Sure. Routes 1 through 5 have a lower residential proximity score and thus a lower impact on residences as compared to Route 65, which was carried forward for further analysis. Correct?
That's correct. And as Mr. Worth pointed out, at least he has it in testimony, is that this is one factor to get the whole score. It's a composite. But you're right, for that particular factor, residential proximity, these lines, which are more in the east-west, north-south type of alignment, do have a better proximity score, which is that disagrees with his position that typically lines that are along roads would be mostly in people's front yards. So I don't know how that fits into these particular routes, but that's true.
Are you saying that if they do run close to the roads, that they're going to be close to someone's house?
That was Mr. Worth, as I recall, that was Mr. Worth's thesis that typically people build next to roads. Therefore, if you build a line along a road, you're going to be nearer to their homes. But in fact, these lines, which are at least the ones that are presented here, that were in the north, south, east, west direction, don't appear to show that as far as the residential proximity score. And I have to also mention, I think it's only fair to say that the work that NextEra has done to microsite some of these lines has probably changed Route 65's score for residential proximity, probably dramatically, to tell you the truth.
But what you're saying is that you believe that Mr. Worth's statement about running the routes down close to roads has a greater impact on residences. That's essentially what you're.
I don't believe that's necessarily true. I don't think the slide as you've shown it here depicts that. I don't know why, but it doesn't show it.
You don't know why it depicts it?
I don't know why his statement would be wrong, but given their scoring methodology, the routes that run north, south, east, west actually look a little better for residential proximity. But again, Route 65 has not been updated to reflect the changes that have been made to it.
And in fact, routes 1 through 5 have a lower impact on cropland in the right-of-way, correct?
According to the presentation you've given me to look at, yes, they have.
Mr. Hados, it's my understanding, and correct me if I'm wrong, that Casey State staff and NextEra, and perhaps even the SPP, contend that the main project benefit for this Blackberry project is congestion reduction. Do you agree with that?
It's the cost associated with congestion is the reason for it, I would say.
I'm sorry, I did not mean to interrupt you.
It reduces the cost of congestion, therefore it serves as an economic benefit. The real reasons for an economic benefit, not necessarily just reduce congestion.
Is the basis for the reduction in congestion the proposed additional capacity of the Blackberry line? That was a bad question, I'm sorry. Is the basis for the reduction in congestion that the staff and NextEra and perhaps SPP are seeking in the grid itself addressed by proposed additional capacity of the Blackberry line?
I believe that statement's correct, that the Blackberry line will reduce congestion to the grid. And that's what was presented through SPP and their plan.
Do you agree that SPP tariffs would permit new wind and solar projects to interconnect into the Blackberry line if developers or owners of those projects meet SPP tariff provisions for the interconnect?
Yes, it's an open access tariff, so anybody that would want to connect to a line and made a proposal that was studied by SPP and their various groups, if that showed that it was, I guess, going to not, that it was available to them, then it could work that way.
Would you agree with me that once the commission issues a line siting permit and the line is constructed, the KCC has no authority to preclude wind farms or solar farms or other renewable energy resources from connecting to the line, even if the environmental impact of those renewable energy resources is significant?
You know, I heard that question the other day. I think that's correct. I would, you know, again, here I am going to give you legal advice again, but I think the certificate of convenience that was given to NextEra is only about 2 endpoints. I'm not sure if you added another endpoint somewhere in the middle, you wouldn't have to come back before the KCC, but I'd like to see that explored sometime.
But once that, I guess, to make sure that I understand, based on what, as the project sits right now, once the commission issues that line siting permit, understanding that the line would have to be constructed, but once it issues that line siting permit, the KCC has no authority to preclude wind farms or solar farms or other renewable energy resources from connecting to the line, correct?
I think that's accurate. It would be the SPP that would have that authority.
And that's the case even if the environmental impact of those wind farms or solar farms or battery farms is significant.
I'm not aware that renewable energy has any type of restraints from environmental impact.
Would you agree with me that the commission held a public meetings in Iowa and Girard, Kansas on March 1st and 2nd, respectively, in an attempt to comply with the commission's statutory obligation under KSA 66-1178 to hold a public hearing in a county in which the transmission line is proposed to traverse?
Well, if I can unpack that a little, I would say I would agree the commission held public meetings in Iola and Girard, and I was present at both of those.
And those public meetings were an attempt to comply with the commission's statutory obligations to hold public meetings or public hearings?
I didn't object to the question on the basis it asked him to make a legal conclusion about the purpose for the hearings.
I'm asking if he knows. If he doesn't know, he can simply say, I don't know.
It's sustained. The objection is sustained. Mr. Kimmel, please proceed.
And you indicated you were at both of those public meetings, correct, Mr. Hanos?
I was.
And you'll agree with me that before the public meeting, KCC staff and NextEra met with the public and participated in a question and answer session?
I'm
I
sorry.
didn't hear an answer.
We did. I'm sorry.
did you say you agree?
We did meet with the public and participate in the answer sessions, yes.
And you said that you participated in that question and answer session on behalf of KCC staff each night, correct?
Yes, I did.
I do believe that you know a man by the name of Justin Grady, who's a KCC chief, correct?
Justin Grady is, I'll probably get his title wrong, but yes, he's part of the utility staff, the chief of financial and a lot of other words, but that's what yeah, he's here.
Sure. And you'll recall that Mr. Grady participated in the question and answer session of the public meeting held in Girard from a remote location?
I believe that's correct, yes.
And when Mr. Grady appeared at that March 2nd meeting in his capacity as a KCC chief, he spoke in that capacity, did he not?
I assume he did, yes.
And as part of his duties that evening, Mr. Grady addressed, among other things, questions raised by the public related to the transmission line congestion and renewable resource connections to the power grid. Do you recall that?
Vaguely, Mr. Kimball.
Commissioner, this is really difficult because I wanted to be able to address Mr. Brady's statements, but it's going to, because I'm on the phone, it's really difficult. But I would move to admit Mr. Grady's statements from the March 2nd Public Hearing Commission meeting in Girard from the timestamp of 29 minutes and 11 seconds through 34 minutes and 49 seconds.
We, NETE Southwest objects to the admission into evidence of any portion of the question and answer session of those proceedings. Those were not official parts of the commission's hearing. Those were not noticed to be on the record, and the on the record portion of the hearing followed the question and answer session where landowners were given an opportunity to speak. The question and answer session was off the record and for the benefit of the landowners who came to hear more about the project.
Staff also objects on the basis of the official public hearing portion was the public comment period which happened after the question and answer, and the commission was not in the room for the question and answer. It was not part of the official record of the public hearing.
My response to that, Chairwoman, is that it doesn't matter whether or not it was part of the official public hearing. This request for admission, admitted to be admitted is based on a party's statement that is clearly admissible. The witness here established that he spoke and answered questions in his capacity as a KCC chief. The staff chief, that staff is a party to this case, and therefore this is a statement by a party opponent in this matter, and it's admissible.
The statement was made by a staff member, but that staff member is not testifying or answering the questions that you're here today can answer those questions for you. The best evidence of those statements are in staff's R&R from 22-419, which is already in the docket. And if you have questions about Mr. Grady's opinions, you can address them in the R&R that was already taken notice of in this docket.
Mr. Kimmel, I'm going to sustain both objections. Would you proceed on, please?
As part of your review of the routing study and other reports that NextEra has provided, can you point to any of those reports in which NextEra considered the effect of interconnections or additions of wind and solar farms in the area of the Blackberry line on the overall goal to reduce congestion?
That is not in the docket.
So nothing that you reviewed, is that a fair statement that is correct, that nothing that you reviewed indicates that NextEra considered the effect of the additions of wind and solar farms in the area on the Blackberry line?
I did not review them. They're not in the scope of the docket, which is one of the reasons we didn't review them. And it was not brought up.
Were you aware that solar and wind developers are already requesting space on the Wolf Creek to Blackberry line?
I've not looked at the generation interconnect queue recently, so I'm not aware of that.
You have reviewed that interconnect recently?
No, I have not. I have not reviewed it recently. I did not review it for the purpose of trying to determine if there were renewable energy sources trying to access to that particular line that's not built yet, which seems like a bit of a stretch.
It seems like a stretch?
To try to get on a line that's not built yet, yes.
I'm sorry. I don't know if there's a delay.
There may be. Let me see if I can. Does this help? I'm right on the microphone now. Maybe it'll help. I'm not aware of any renewable energy resources trying to connect to the Blackberry to Wolf Creek line.
Well, I can assure you, if you did review that website from SPP, and I assume that you're referring to the SPP commercial data forecast.
We object to the entering or attempts to enter testimony by counsel. The witness has stated that he is not aware.
I'll sustain the objection. He stated he was not aware. Can we move on with the questioning, Mr. Kimmel? Thank you.
Mr. Hanos, if new renewable projects pack the capacity of the Blackberry line, haven't we eliminated the Blackberry line's capacity to relieve congestion?
That would have to be studied by SPP, and I'm certainly not, don't have the expertise or the information to make that determination.
Well, I think that you indicated that if there's excess capacity on the line, then wind and solar farms can connect to it, correct?
That's my understanding. They can apply to SPP, who will then study the situation and determine if that capacity is available to them. If SPP made that determination, then I would assume they would be allowed to connect to it.
And if there's I guess I will again submit to you make the assumption. I ask you to make the assumption that there are wind and solar farms that have already asked for connection to the Blackberry line.
I can't make the assumption. I just don't know.
Well, I'm asking you to make the assumption.
Objection, he's asked, and this question has been asked and answered several times now.
I agree. The witness has asked and answered this question several times. Can we move on with our question, Mr. Kimmel?
Would you agree with me, Mr. Hanos, that if new renewable energy projects are developed and connected to the transmission lines with lots of new capacity, like the excuse me, would you agree to me that renewable projects will tend to go to new transmission lines or be constructed around new transmission lines with lots of new capacity, like the Blackberry line?
No, I can't agree to that. I just don't know. They're going to connect to where they have a economic point to connect and where their capacity is available to put on a line. It could be an old system, it could be a new one.
For my next line of questioning, Mr. Haynos, I'm going to ask you to refer to 3 exhibits. Exhibit DW5, page 16 of 90. Exhibit DW2, page 16 of 80. And exhibit JB2.
Okay, can we take those one at a time, or do we have to do them all together? I'm trying to pull them out here if we can.
I'm going to ask you to pull them up, just pull them out so that we can talk about them, because we need to talk about them all together.
I don't think those are in my testimony, but if I have a copy of Mr. Worth's, part of Mr. Worth's testimony. I don't think I have all those with me, though. I'm looking right now.
Yeah, I'm happy to wait. It's fine.
Where I'm at right now, I have DW1 available, it looks like, in its entirety. I do not have the other exhibits you were referencing available to me right now. They're not in my testimony.
Could I ask the commission, since I'm working off of a phone here, to pull up on the screen exhibit DW2, page 17 through page 17 of 91 for the witness?
We'll look to see if we have it. Hold on, Mr. Kimmel.
What was admitted into the record?
We're working on it. It's hard to read the page number.
I believe it's in the docket. It's identified as exhibit DW2, page 17 of, I think it's 81, or on the, because of it, this is the figures identified as page 16 of 80. There's just some issues with the cross-referencing there, it looks like, from what was it.
Mr. Kimmel, we do have it up on the screen.
Good. And Mr. Haynos, just so that we make sure that we're looking at the same thing, this is from exhibit DW2, page, it says at the bottom, it says page 16 of 80 in black, and says exhibit D in red, exhibit DW2, page, I think it's 17 of either 81 or 91.
Yes, I understand. I recognize the picture also. I believe it's the homestead of Mrs. Smart.
Yes, that is correct. So right in the middle there, it's the crossroads of Southwest 500 Road and Southwest Colorado Road in Anderson County, Kansas, correct?
Yes.
And you'll see that you'll agree with me what this figure illustrates from DW2 is the original route and the proposed route that NextEra presented on when Mr. Worth submitted his testimony on or about whether it was January of 2023. Correct?
I don't know when he did the alternative route, but it is the lines that's in my screen, which are sort of red, they show a kind of a corridor. I believe those are in the original, that's the original proposed route. And it shows the structures on it as well, I think.
You agree with me that the red line, and we'll kind of, let's call it pink, is the original route, and the green line is the to the west is a proposed alternative route, correct?
My understanding that the alternative route, which is presented Mr. Worth's, maybe one of his rebuttal testimonies, is the green line. It looks similar to it anyway. And the pink lines definitely look like the proposed route.
Well, I guess I think that we can agree that Exhibit DW2, page 17 of 81, illustrates the original, DW2 was the original proposed route that NextEra presented in the docket. Is that fair?
Yes, the pink lines, it's my understanding, that's the original one for the docket.
And you have no disputes with that proposed route that NextEra presented in that illustration, correct?
I don't. I mean, I looked at it. I looked at some measurements from it. I looked at the measurement from the house to the line and from the various outbuildings to the line. I think it's around between 600 to 750 feet away.
I know that the day's being long, Mr. Hanos, and what I'm asking is that I was referring to the proposed route, the potential reroute.
The potential reroute, okay.
That the potential reroute that's illustrated in green, you're not suggesting that that's an unreasonable route that NextEra proposed, correct?
I don't even suggest the original route is unreasonable. I think it's acceptable. The route that NextEra proposed. I think the cost, if I remember right, was around $75,000 to make that alternative. I'm good with that. I think it's an acceptable route. It does resolve the issue of getting the line further away from the McGee homestead. At the same time, the original route was only 700 feet away, and we have several homes that are within 300 feet. That we were trying to deal with.
So just to make sure the record's clear, you don't think that the potential reroute is unreasonable, correct? That's illustrated on page 16 of 80.
If the commission approves this route in its entirety, I don't think that it's a little more than a microsighting to me, but if that's what it would be, I don't see that as being unreasonable.
And then I want to refer you to Exhibit DW5, page, in red it says Exhibit DW5, page, I think it's 16 of 80.
We're looking for Mr. Kimmel, and we'll bring it up.
Thank you.
Thank you.
Mr. Kimmel, while I'm waiting, can you give me an idea, perhaps time-wise, how much more time you'll need on your cross so we can plan a break?
I can't right now, Chairwoman. I just can't. It's going to be dependent upon how smoothly. This is a little bit more cumbersome since I have to be calling in on the phone, but it's working out.
Okay, but more than 30 minutes, you think?
Perhaps, yes.
Okay, thank you.
Mr. Hanos, just let me know when they get that exhibit pulled up on your screen, please.
Yeah, some of these aren't in order, so it's just proving to be a little bit more difficult.
I'm not able to say yes yet, Mr. Kimmel. Did I lose anyone, or are you guys still pulling it up?
No, we're finding it. We're getting close. It's just where it was located. Okay, it's now on the screen and I see Mr. Kimmel, you're now in the, we see a video of you as well.
Yeah, I'm hopeful. I'm going to keep you on phone, so if I lose you, then I will. I'll just lose the screen and not lose time trying to call in, if that's okay with you.
Sure.
So, Mr. Hanos, I want to. What you're looking on your screen is from DW5. You recognize that as the same location that we were just speaking about in regard to Exhibit DW2 near the McGee home?
Yes, I do.
And do you see that the route that was proposed to the McGee's in DW2 no longer exists in Exhibit DW5?
There's only one route presented on this exhibit, which is the original.
The proposed reroute does not exist, correct?
It is not on this. You're correct.
So you may recall from Dusty Worth's testimony yesterday that the exhibits illustrated in DW5 are the final proposed route that NextEra is submitting to the Commission for approval. Do you recall that?
I don't recall that.
I will submit to you that he testified that Exhibit DW5 is what the Commission has, what NextEra is submitting to the Commission to approve as the proposed route. Can I get a stipulation from NextEra that they don't dispute that?
I think we can proceed with just subject to check, Mr. Kimball. I would agree with that.
Now, you previously spoke about the property owners needing to be able to negotiate with NextEra on rerouting lines. You remember that?
I do.
Okay. I suspect that if I ask you, I'll ask you this question. Do you know of anywhere in Dusty Worth's rebuttal testimony that was submitted with Exhibit DW5 in which he acknowledges that NextEra has removed the potential reroute proposed in Exhibit DW2?
I didn't adopt Mr. Worth's testimony. I don't recall that in his testimony. So I don't know.
And I guess my question you did review Mr. Worth's rebuttal testimony that was submitted on or about March 22nd, correct?
I have read a lot of testimony, so I'm sure I have. I've seen this map before. I didn't recognize it as being taking the alternative route off the table, which is, I think, what you're alluding to.
Right. I'm also going to refer you to Exhibit JB2.
Now that you're on, Mr. Kimmel, can you put that up on the screen, JB2?
I will try. I hope I don't lose you.
Okay. We still have you on the phone.
All right. Can you see exhibit that's shown as JB2 on your screen?
Yes, I can see it. Yes, sir.
In Exhibit JB2, you see where it identifies NETE Southwest proposed route, NETE Southwest alternative reroute, and McGee's Marsh proposed reroute.
Yes, I see that. I do.
And I'll represent to you that, well, maybe I can. This Exhibit JB2 was submitted, obviously, with Ms. Blakely's March 22nd, 2023 rebuttal testimony. At the same time, in other words, at the same time that Dusty Worth submitted his testimony and his revised exhibit DW5. Okay, can we agree to that?
In an effort to moving the process, subject to check, I would agree to that.
As you sit here today, can you tell me what you understand as any alternative routes that NextEra has on the table for that area near the intersection of Southwest Colorado Road and Southwest 500 Road in Anderson County, Kansas, near the McGee Smart residence?
As I understand it, the line that's represented in red and labeled as NETE Southwest Alternative Reroute is the one that, based on this testimony, I assumed was on the table.
And is that the reroute that you understand is going to cost NextEra $75,000 to implement?
Yes, sir. That was my recollection. It would add $75,000 to the cost.
And you do, and you're not opining as to whether or not that additional $75,000 in cost is unreasonable, correct?
I don't think I addressed that either way. I did address that the route proposed by Ms. Smart is unreasonable. I think that is asking a little much when you're already 700 feet away from the proposed line.
And I just want to make sure that I understand you. You're not suggesting that the reroute identified on Exhibit JB2 in red is unreasonable, correct?
I don't believe it is unreasonable. I think it is subject to some considerations for NextEra. I think she, as I recall, emphasized that in that particular reroute, they needed to be able to evaluate the route to make sure that they could in fact achieve it. And they hadn't been allowed access to property to make that determination yet. So it may still be up in the air because of that. But assuming those very minor details get worked out, I believe it's a reasonable route.
And it's your understanding that that route is on the table, correct? For NextEra?
That was my understanding from Ms. Blakely's testimony, but I can't really speak to her testimony or to Mr. Dirtworth's. I recall.
I'm asking you from just a reasonableness of fairness and fair dealing. Would you, based on your review of the documents, would you believe that there was a reroute that NextEra was proposing for the area near the McGee property?
I believe that the reroute as presented in this document you're showing me right now is more than generous. And I wouldn't recommend the commission oppose the additional $75,000 for that. For a variety of reasons, by the way.
Well, I will represent to you, I've reviewed Mr. Worth's rebuttal testimony that he submitted with DW5, and it makes no reference to the removal of the proposed route, and it's simply unclear to me why it was done by NextEra.
I can't shed light on what Mr. Worth was trying to show in his testimony. I will say that when we discussed response to staff data request 42, it's along the same line of questioning that you're talking about, Mr. Kimball, and that is that if there is a more favorable route that's more favorable to the homeowner, I believe the commission should lock that one down, so to speak, rather than to leave options out there that if it's practical and can be done, I think that you have to allow the company to evaluate the route to make sure that it is in fact able and feasible to do it. Then we should lock down some of these alternatives that go to the ability of moving the line away from homes. Now, like I said, the line here was already over 700 feet away from Ms. Smart's home, which was way more than it was for any of the 9 or 10 customers that I outlined in DR 42. So I think this proposal is more than generous of NextEra to provide if they wish to honor it and they can evaluate it carefully. I think it should be locked down by the commission as part of their recommendation rather than have two routes out there that can be negotiated on.
Thank you for that. I'll stop sharing my page for just a second. Mr. Hanos, I am now going to pull up Mr. Worth's rebuttal testimony from March 21st, or I'd ask you to pull it up, from March 21st, 2023.
I do not have it available.
Mr. Kimball, if you could pull that up.
For just a second.
Mr. Kimmel, we're also trying to find it. You got it? All right, good.
And I will, can you see exhibit?
Yes, I see.
I see a document. Excuse me? I see a document has the word conclusion in bold near the bottom. Exactly, right. And this is Dusty Worth's March 21st, 2023 rebuttal testimony. I'm going to read into the docket what Dusty Worth wrote on line 17. In Exhibit DW5, I provide a full set of updated routing maps for the entire proposed route. Do you see that? I do, and I also recall Mr. Worth saying that, or maybe Mr. Mayor saying that this is still in flux. We're still negotiating micrositing changes, and we will be, for a while. So I don't know if updated means final. Well, I guess that Mr. Schulte gave a definition of what micrositing was earlier today. Do you recall that? I don't recall the exact words. I remember the discussion. And I think he defined micrositing as an area within the general.
I'm sorry, Mr. Kimmel, I didn't catch the last part of your question.
Sure. What is your understanding, Mr. Hanos, of what micrositing is? Generally, it's going to be making modifications, typically, as I've seen it, to avoid some type of operational concern like a farming operation, or to move the line further from residences. I would say the times that I've seen micrositing used, it's almost always to move it away from residences, but I can see them doing that also for farming operations. Generally, it's going to be in the same area. Could it be a half a mile away? I assume it could. I haven't seen a whole lot of those move that far. Usually it's a few hundred feet. I guess the reason why I asked that question is Mr. Schulte defined microsite earlier today. I think the record will reflect of moving facilities within the general corridor in order to allow things like a combine to move. In other words, like moving poles. I think that's that's an example of micrositing. That definition that he gave has some very vague words in it. So it's a concept more than it's a very finite definition. Well, I will represent to you that, well, not to represent, I will, Mr. Worth previously testified that DW5 provides a full set of updated routing maps. And you may recall from Mr. Worth's testimony that DW, from his rebuttal testimony, that he's proposed some changes to the route he originally proposed as reflected in DW2. Would you believe that? Do you understand that? That's correct. And what he said is it's not the final. He said it was an updated version. So it was the most current version when he filed his testimony. We also heard testimony that negotiations are continuing. And I'm sure if this is the proposed route that is approved by the commission, that there will be additional modifications. Well, just based on what Mr. Worth has stated on page 11, lines 17 and 18 of his rebuttal testimony, that this is the updated route for the entire proposed route. And in his oral testimony, I believe he said that that was the final route that would be proposed, understanding there could be some micro-siting changes. With the understanding that that final route was not submitted until March 22nd, and the public hearing in this case was held on March 1st and March 2nd, how can the public have been afforded the opportunity to review the proposed route that wasn't on March 1st and 2nd, that wasn't submitted until March 22nd?
There's ongoing negotiations with these landowners, as I understand it. So even today, if they have not reached a deal, they're still negotiating what that micrositing would look like. Now, I don't know what the minimum maximum variation would be for the term micrositing. And I have to kind of leave it at that. What he gave you here in his exhibit was the current routing map at the time he filed his testimony. If you state that he said it was somewhat final at another time, so be it. But we also heard testimony saying that there's ongoing negotiations and subject to inspection of the property to make sure they can in fact achieve a modification, which is part of that, as is the cost, by the way. I think those negotiations continue and will continue probably right up until the line's built.
And what you're talking about is making those micrositing changes, correct? That's what the commission would expect for micrositing.
But I think we're talking about different definitions of micrositing. Micrositing, I think, includes some pretty significant moves, not just moving a pole so a combine can get through. So, I don't know what that range is, but I think those will go on until the commission has a final rule.
So I guess I can only go off what Mr. Schulte defined as micrositing, and that was moving facilities within the general corridor.
Well, I would suggest that you should ask Mr. Worth what it would be rather than the attorney. But because I can't give you a really good definition, and I think it's a term of art, to tell you the truth.
Mr. Kimmel, it's now almost 3:30 and we're due for a break. So are you about to wrap up now with this witness?
I probably got another 15 minutes or so, Commissioner.
I think we will take our break, okay? So
Right now?
yeah, it's 3:28. Why don't we come back here about 3:40? How's that? Give everybody a 10-minute break. So we'll be back on the record at 3:40. Thank you. Please remember to mute your microphones. Okay, folks, it is 3:40 and we are back on the record. And Mr. Kimmel says he's got a few more minutes and with this witness. So, Mr. Kimmel, if you'll proceed, I'm just going to say this. We've had a long day. Oh, he can't hear. I'm not muted. Can anybody else hear me?
I can hear you, Chair.
Okay.
Yes, Chair, it's fine. Mr. Kimmel, do you need to call in again? Do we have another way to contact him?
All right. We'll stand at ease here. Did you call?
I messaged him.
Okay. Mr. Kimmel, I think we hear you.
I'm on. Sorry about that. I think
That's
that,
okay. Yeah, okay. So I was just saying that you have a few more minutes with this witness and that folks it's been a long day already in this compressed time schedule. And so just if you can, for the remaining time with this witness, if we could just be more succinct to all parties. But Mr. Kimmel, will you proceed?
Mr. Haynos, are you ready to proceed?
I am.
When you said that you were at the March 1st and March 2nd public meetings in Girard and Iola, Kansas, correct?
I was, yes.
And you'll agree with me that NextEra and the KCC made at that public meeting opening statements and answered public questions as part of the public question and answer portion of those meetings?
I object to the statement that opening statements were made. Opening statements has a specific meaning in an evidentiary hearing, and there was no opening statement made at the Iola or Girard public hearings.
Your objection is sustained, Mr. Schulte. Thank you.
Mr. Haynos, did NextEra and the KCC staff present PowerPoint presentations at the public question and answer portion of those March 1st and 2nd meetings?
I believe they did, which just laid out the information about the line.
And you'll agree with me that the McGee's were not allowed to make or present a similar PowerPoint presentation at those meetings, correct?
I don't recall that.
I'm going to object to this line of questioning. This has been set forth in pleadings. NETE Southwest filed a responsive pleading, staff filed a responsive pleading, the commission issued an order. There's really no relevancy to the reasonableness of the route or the necessity for the line in trying to relitigate something that has already been addressed in pleadings.
I'm asking factual questions of the witness to address a relevant issue associated with procedural requirements under the Kansas APA. We can move through this very quickly, but this is absolutely relevant, and I'm asking a factual question. Furthermore, the statements in pleadings or the briefing of counsel are not evidence. I'm simply asking the witness to provide factual evidence for the record.
Mr. Kimmel, I am going to sustain the objections. If you'll continue on, please.
Mr. Hanos, will you agree with me that at the public hearing portion of the meetings on March 1st and March 2nd, that when the commissioners were present, the commission considered statements made by non-parties?
I believe everything that went before the commission is on the record. I don't recall what all was said or who said it, but I know that when these occur, there is a transcript kept of that.
And you will agree to me that the public made comments at that public hearing, correct?
As I recall, they signed up to, anybody put their name on the list could make comments.
And the people who put their name on that list stood up and made public comments, correct?
As best I recall, yes. Everybody that was on the list got a chance to speak.
And at that, and those members of the public are not parties of this case, correct?
I don't know that. I don't recall.
Objection. That mischaracterizes what happened, what the evidence is. There were people who were parties. The McGee's spoke at one of the public hearings in the public comment period.
There were non-parties that spoke as part of the public comment portion of those public meetings, correct?
This question has been asked and answered as well.
I would agree. The question has been asked and answered, Mr. Kimmel, if you could move on. Thank you.
During that public hearing portion of the March 1st and March 2nd meetings, will you agree that at the hearing, the commission did not give the McGee's an opportunity to challenge or rebut each of the statements made by non-parties at that public hearing?
Objection. Yeah, mischaracterizes what happened at the hearing. McGee's were given a chance to speak, and in that time they could have rebutted or made comments on whatever they wanted to make comments on. And they did so.
And I would add to the objection that, again, the staff's position on what happened, NETE Southwest position on what happened, and the legal implications of such are all set forth in pleadings that have already been filed before the commission.
I would sustain both objections here. Mr. Kimmel, if you could move on, I would appreciate it.
I'm almost done, Your Honor, or excuse me, Commissioner. I would like, before I close, to ask the commission to admit McGee Exhibit 21, page 4, which was previously discussed with Jacqueline Blakely.
Did you discuss this objection? Did you discuss this with Mr. Hanos?
I discussed this exhibit. I'm not sure who's talking, but I discussed this exhibit with Jacqueline Blakely, and she acknowledged that her signature was at the bottom of the page. And I spoke with her about the other exhibits as well, but I'm moving to admit into evidence McGee Exhibit 21, which is NextEra's data request response.
Just to clarify, is that just page 4 of McGee Exhibit 21 that's being moved for admission?
For right now, yes.
NETE Southwest doesn't have an objection to page 4 of McGee Exhibit 21 being admitted into evidence.
Pardon, Mr. Schulte, I did not hear that.
Sorry, I just stated that NETE Southwest does not object to page 4 of McGee Exhibit 21 being admitted.
Mr. Latif, were you trying to say something earlier?
We don't have a general objection to this piece of evidence. It's just an objection to admitting evidence for a witness that didn't author it, and for Mr. Hanios. It should have been motioned and when Jackie Blakely was testifying.
Yeah, I don't know what rule says that I have to move at this particular time I have a question for the witness. Once I establish the foundation for the exhibit, it can be admitted at any time. It often occurs in which evidence is admitted altogether at the end of a trial or otherwise.
Thank you, Mr. Kimmel. We will admit this piece of evidence into the record.
I also spoke with, thank you, Commissioner. I also spoke with both Ms. Jacqueline Blakely and Dusty Worth in regards to McGee Exhibit 21, pages 5, 6, 7, and I would move to admit those documents into evidence in this case.
Is there a reason you didn't ask for the whole document 4 through 7 to be admitted?
I just did.
Oh, yeah, but you asked for 4 and then you stopped, and then your new request is 5, 6, and 7 pages.
Correct. That's a mental impression that I had, that you're asking me about my mental impressions that I'm just not really interested in sharing with you, Commissioner.
Are there any objections to this admittance of 5, 6, and 7?
We'll need just 1 minute to review.
Absolutely. Mr. Schulte, do you have a response?
Sorry, we're having some difficulty because Dusty Worth testified 2 days ago, and we're struggling to remember what the nature of the cross-examination was.
Are you disputing that these were statements made by Dusty Worth on behalf of NextEra?
No, they appear to be accurate copies of DR responses.
They are accurate, and you've had them for several days, Mr. Schulte. I'm simply asking you to, I guess I'm asking for admission. I don't know what your objection would be. They're clearly statements made by you or your agents in the scope of their agency. They're admissible. They're in writing. They're signed by your agent.
Yeah, and all I expressed was that we were still reviewing, but we don't have any objection to McGee Exhibit 21, pages 5 through 7 being admitted into evidence. I will note that there are zip files attachments referenced in these data requests. My understanding of the motion is that it's just the pages of this exhibit, not the zip file attachments that are being admitted. Is that an accurate understanding of the motion?
Mr. Kimmel, that's my understanding as well.
Exhibits. Well, I think that, yeah, that's fine.
Then we don't have an objection.
Seeing there is no objection, pages 5, 6, and 7 are of the are admitted into evidence. Okay, does that conclude?
I have one more question for the witness.
Okay, very good.
Mr. Haynos, at the March 1st public hearing in Iola, Kansas, you indicated again that you were there, so you're aware of the scene at that. Do you recall the meeting room at that night in Iola?
I do.
Which I'm showing you what's marked as the McGee Exhibit 29_0001. I will represent to you, this is a screenshot of the March 1st, 2023 public hearing in which the commissioners were present. Do you recall this general scene at that public hearing?
I do.
Does this photograph fairly and accurately represent where the commissioners were sitting that night at that public hearing?
Yes.
And just so that we're understanding, the commissioners, starting from, you'll see there's 7 people illustrated in the photograph.
Yes.
Commissioner, I would like to admit into evidence McGee Exhibit 29_0001.
NETE Southwest objects with regard to relevance. I don't see the relevance with regard to the evidentiary issues before the commission in this proceeding.
Mr. Kimmel, can you respond to the relevance of this picture?
Yes. Statutory provision requires the commission to hold a public hearing pursuant to KSA 66-1178B. This is a photograph of that hearing. It's relevant. It illustrates a depiction of that hearing.
It's we would object because that's legal argument. If I,
That's not, you'll object because it's a legal argument?
yes, it's not relevant to the evidentiary hearing that we are in now. It also is a incomplete depiction, as Mr. Kimmel calls it, of the proceeding. It lacks context and it's.
The witness can testify, and he testified that it accurately represents the meeting and who was sitting at the front of the room.
Mr. Kimmel, you're right. We'll admit this into evidence and give it the weight it deserves. It is a picture of one direction of the hearing, not of the audience. And I think you can see the dais is very small, but we will admit it into evidence and give it the weight it deserves. Thank you.
Thank you.
Are there any other
Mr.
questions for this witness?
Yes, Hanos. Will you please identify, are you represented previously that you were, let's back it up. Do you know who the first person on the left in the photograph is?
It's a little blurry for me, but I think I can pick them out for you if you want me to just name them.
The first person on the left is who?
I believe it's Commissioner Keene.
And the second person is on from the left is
Chair Duffy, and I assume, I can't see the face on the third person. I'm assuming that would probably be Commissioner French. In the middle is Hassan Latif. He was acting as kind of a host or a coordinator for the operation. As you move to the, I don't know too many of those. I'm going to guess that's Jacqueline Blakely, Miss Davis, and then Andrew Schulte on the end.
And Mr. Schulte is clearly NextEra's attorney, correct?
He's a counsel in Kansas, yes. And then Miss Davis, as I recall, is an attorney for them. And Miss Blakely is a director of some sort that is connected to NETE Southwest.
Miss Davis is an attorney for NextEra, correct?
I believe so, yes.
The person in the middle there is Mr.
That's Hassan Latif, I think. He was serving as the kind of the coordinator and the Toastmaster, if you will, for the hearing.
And he's also staff counsel, correct?
Yes,
in this matter?
He is.
Thank you, Mr. Hanos. I'll pass the witness. I really appreciate the time that you taken with me, Mr. Hanos.
Certainly.
Thank you, Mr. Kimmel. Okay, at this point, I'm turning to Evergy. Do you have questions of this witness?
Yes, I do. Good afternoon, Mr. Hanos. Can we clear the picture off?
Yes, Mr. Kimmel, thank you.
Afternoon, Mr. Hanos. On page 19 of your direct testimony, starting on line 2, that's where you're recommending that NextEra install dead-end structures at highway crossings, correct?
I believe that's so. I'm trying to find my testimony again. Get mixed up with a bunch of other things here.
Okay.
Page again.
It's your direct page 19, line 2. It's just your recommendation about the dead-end structures when they cross highways. Just let me know when you're with me.
Page 19 of my direct. I see that as a question regarding minimum height of line over cultivated agricultural land. Is it a different one of the many different versions of this that was filed?
On line 2, direct testimony, line 2, on testimony. Well, I meant your confidential competitive version. Is that what you're looking at?
I think, no, let me get to that one.
Ms. Kafer, do we need to go into a confidential session on this?
No.
Okay, thank you.
Okay, for the version I have, my line 2 is the same as my public version. I'm not sure.
I don't even know that we really, I mean, it's mine on line 2, towards the end, it says, I further recommend the commission require dead-end structures to be placed at both ends of any span crossing major highways. That's my question, the foundation for my question. That's your recommendation, isn't it?
It is my recommendation, yes, ma'am.
Okay. My only question about that is there a reason, or what was the reason that you made that recommendation for crossing highways and not railroad crossings?
For a couple of reasons. One, I saw on the highways that they would be more subject to randomness of traffic for public safety. You don't know when cars are coming or going. And usually with trains, it's been my experience, utilities have direct communication with that railroad, and they can, alter train traffic much more effectively and quickly than they can highways.
Okay, so that was intentional to have it be on the highways.
Yes, it was.
Turning to the routing study of NextEra's that's in Mr. Worth's testimony is DW1. And I'm going to see if I can do all this, bringing this stuff up. On page, do you have his testimony there?
I have the routing study here, yes.
On page 9 of Dusty Worth's direct testimony, it was filed January 24th, 2023. This is where he sets out the routing principles or the factors that they looked at, correct?
Yes, it is.
And the second to the last one there is follow existing rights of way, such as for roads or electric transmission lines as appropriate. So that was one of the factors that was considered and weighted in the study, correct?
That's a principle that he gave, yes. It was more likely to follow the transmission side, but yes, that's it.
And when you're routing new lines along existing lines, is that really more beneficial if you're talking about one single utility that's owning both lines versus two different utilities?
I think with one single utility, it would make more sense because you wouldn't have these situations like Mr. Vetch was talking about earlier today, where you have to do this coordination, otherwise you have a lot of traffic back and forth on this landowner's property. I'm not convinced that we really have established the fact that this should be a principle, that you should necessarily feel like it's a opportunity to place a line next to an existing transmission line. I'm not sure that really has a lot of merit, to tell you the truth, but that was the condition they set out. Mr. Worth testified that he thought that was a kind of a business practice or a best practice in the industry. I'm not sure I agree with that, but it is listed there.
But would you agree though that if it was one utility who was going to, I mean, they could stay within their easement that already exists, it would be an important factor if you're talking about just one utility versus a new utility coming in and putting a new line next to another utility?
It would certainly make it less complicated. I've been around a lot of pipeline right-of-ways that have multiple pipelines in them, and they're always difficult to work with.
And if it was just one utility, one of the advantages would be the one utility then could combine both lines on one structure.
I'm not sure I heard all of your question, but I think you asked if it would be an advantage if they could put them on one structure if they were all the same operator. That certainly is, I think, reflected in my testimony. One of the things that when I recommended to not approve a double circuit, it's because of the fact that it's two different utilities trying to use the double circuit. That's how I see my recommendation anyway. If it was on one utility, I think it would take a lot of this complication out, and it would have been a viable solution. It may be in the future.
And at least for the landowners on the property where the second line is going in, they're not going to view that as a positive aspect of how the line's being routed, correct? That's what we've seen in the public
Yeah.
hearing and the.
And it's definitely reflected in my excerpted comments that are attached to my testimony.
So on page 11 of Mr. Worth's direct testimony that we just were looking at page 9, if you go to page 11, there he indicates that they assigned, in doing the routing study, they assigned weights to the criteria. They say based on their experience with similar transmission line projects across the country. So they placed weight on each of those factors in their scoring process, correct?
They did, yes.
And the lower the weight they placed on it, does that mean that that was had less impact on them?
Yes,
It was more favorable.
It didn't have as much impact.
I'm going to. Do I just hit share screen to put something up here from my screen?
Yes, you do, and that should do it. You have the capability.
Yeah, that's not what I wanted. Do you have the routing study?
I believe, yes, I do have it.
Oh, I see what I did. Okay. Well, sorry, I'm gonna cut back out because I'm not getting what I have here. Oh, do I just have the wrong page? I was looking for 53. So what I need is actually the study. Well, if you could go to exhibit DW1, and that's the routing study.
Yes.
And page 53 of 311 is what I have.
I have it. It lists the factors about social, environmental, and so on.
Yes, and then one of the factors on there is the length not along existing transmission line.
I think that must be on page 52.
52 is where it starts. I've got 53, but 52.
It's on 52. Yes, I see it.
So the then keep going, and on page 58 of 311.
Yes.
Okay, so there again, the factor length not along existing transmission line. Mr. Worth gave that a weight of 8, correct?
Yes.
That's 8 out of 10 possible, right?
Yes, it says that is, you wish to avoid the length, you wish to avoid any line that's not along a transmission line. And if you look at the previous example you gave me back in table 3.1 on page 52, he labels that as an engineering factor, and I really do not see an engineering attribute to if that line is next to an existing transmission line or not.
But by giving it a higher weight here, it's kind of a double negative, so it's a little bit confusing. But by giving this a higher weight, it biases the outcome of the analysis in favor of putting the line, routing it along an existing line, correct?
That's correct. I would say that it looks for opportunities to put this next to an existing transmission line rather than not.
And the only other factors that are higher, there's only 2 more factors higher than the 8. Everything else that he's looking at in here is 6 or lower, correct?
That's correct. That's correct.
So if this factor, this length not along an existing transmission line, if that factor was weighted, if it was significantly reduced in how it was weighted, do you know what impact that would have had on the overall results of his study?
Yeah, I looked at spreadsheet and our response to data request 23, and I played around with moving those around a little bit. It changes it. It may make Route 65, which was the proposed route, it may drop it down to second or third place. It wouldn't take much to probably drop it out even further than that. In other words, it's a very sensitive factor to making Route 65 the proposed route.
So would you turn to page 66 of 311 in DW1? Take a look there.
I think I have that. It's about a 3 font, so you'll have to forgive me if I miss something.
It's kind of small, especially this late in the day, I feel like.
Go ahead, I have it.
Okay, so at the top of this, it says route data for the top routes evaluated. So these are the top routes that were evaluated in the routing study. These are the ones that made the final cut for consideration, right?
They are, and it lists the segments there of all the various segments that go that make up these routes. And you'll see that the first 5 or 6 segments, maybe more than that, are all the same for the first 3 or 4 routes anyway. And those are all, I believe, areas where they are adjacent to the transmission line.
So I'd like to direct your attention now about halfway down under the routes to number 422.
Okay. I'm there.
Okay.
Excuse me, I'm not
Yes?
following the page numbers and the screen's not moving. Where are we right now?
They're one off. Okay. 66, is that what you're saying? How about page 66? That's the route data for the top routes evaluated.
Yes, I'm there.
Okay. Under route 422.
Yes.
Okay, I don't know if this will help, but I'll try and put this up. I'd like to confirm with you that if you look at those segments on there, 1, 3, 4, 7, 11, 16, that it would be following this 1, 3, 4, 6, 7, 11, 16. Are you with me?
I think I am. I don't see number 6 in there, but I see 1, 3, 4, 7, 11, 16. Excuse me, these 16, 22, 33, 43, and 44 listed as the segments that are associated with route 422.
Okay, and if we follow that route after leaving Wolf Creek over here, then that route turns south from the proposed route before heading kind of in a generally southeast direction.
I don't know. I've not seen the route plotted.
Not sharing?
I don't
Why is
see.
it not sharing? Are you, can you see what I've, no.
No.
No, I can't. I can't.
Excuse me.
Okay.
Very
Yeah.
quickly.
Yeah.
Kafer, we cannot see that, but David Cohen's bringing it up.
Okay, very good. Thank you. I can't wait to get back in a hearing room with everyone where I can do this my old fashioned way.
I concur.
So what I was trying to get at, okay, so that is the route that we're looking at. I had the map. Does anybody have a better idea? 53, 50, page 50 of 311 is the map that I was trying to pull up there.
Do you want Mr. Cohen to try and bring that up?
Yes, please.
Okay.
Because for some reason, it's not letting me do it. Yep. Okay, there. That. Yeah, keep going up here to where you can see Wolf Creek. Got to go up a little higher. Oh, wait. Now we got to come over a little. All right, there we go. So, well, if you can see it, the coming out of Wolf Creek, then can you follow that a little bit better, Mr. Haynos? The 1, 3, 4, 7, 11, 16 route that's identified as 422.
I'm really not able to make up the numbers, Ms. Caper, but if you will draw your cursor along the track, I will agree to it subject to check. How's that? I can see your cursor. I can see Mr. Cohen's cursor, I guess. I don't know whose cursor I'm looking at.
I'm sorry, he's saying
Reviewing
he can't see where you're trying to go.
I can see the line. I see the numbers. I can't read them.
See, we don't have control here. Yeah, so here, I'm going to try once again to take this. Now, are you seeing my screen?
Not yet.
It's trying to come up.
It's trying. Well, that's hopeful.
Yes, I see it.
There?
Yes, it is.
All right. Okay, so coming out up here, out of Wolf Creek, then there is that the route is 1, 3, 4, 7, 11, 1, 3, 4, 7. You with me now?
Yes, I am.
Okay, so is that route 422? It's south of the proposed preferred route, correct?
It appears to be, yes.
And it does not parallel Evergy's line the way Route 65 does, correct?
I can't tell for sure, Ms. Gaper. What I'm seeing.
Can I ask you subject to check if you would accept that subject to check that route does not parallel Evergy's line?
At this late hour, yes, I would agree, subject to check.
Thank you. So if on the chart that was the route data for the top routes evaluated that we looked at before, it indicates that Route 422 is 94.2 miles long, which is actually shorter than the route that was proposed in the application, correct?
Perhaps barely, yes. Just about the same length, 94.2 versus 94.3 in on page 66 of Exhibit W1.
And also that Route 422, it has 15 angles over 30 degrees, which is near at least the number of angles in the list. And it's near the least number of angles in the list and 2 fewer than the proposed route, correct?
That's correct.
And the length through previously mined area for 422 is equal to the lowest on the list and less than half of the route that was proposed in the application. Is that correct?
Yes.
And the transmission line crossings for 422, it's only one more than the lowest number on the list, correct?
That's correct.
I'm going to object to this continued line of questioning. If, again, our witnesses, NETE Southwest, who has the burden of proof in this proceeding, our witnesses were called first. There was an opportunity to cross-examine them. Dusty Worth is the routing expert. And if there was questions about the relevant, benefits or detriments of certain routes, those questions could have been posed to Mr. Worth. Now that Mr. Worth has testified and been excused, introducing new evidence without an opportunity to rebut it at this late stage in the proceeding is inappropriate and prejudicial to NETE Southwest.
I'm not introducing anything new. Mr. Haynes testified about the weighting factors and how they affect the outcome. And I'm using evidence that NextEra has put in the record to ask Mr. Haynes questions about that impact of the weighting. So I don't think there's any basis to prohibit me from questioning Mr. Haynes on something, whether or not I could have questioned Mr. Worth on it.
I'm going to overrule the objection, but I'm not quite sure where you're going with all this, Ms. Kafer. And at this point in time, if we could move it along a little quicker, I would agree you would have had the opportunity to discuss this with the witness, and you can, of course, with Mr. Haynes, but I'm not quite sure where you're headed here.
Well, if I'd be allowed to continue, I've only been up here a few minutes after waiting many hours to try and ask a few questions about this. So I'd appreciate being given the opportunity to make that point.
I understand.
We would like to reserve the opportunity to cross-examine Mr. Haynes after Ms. Kafer has concluded, based on this new line of questioning.
I'm not thinking that will allow that. So let's continue on, Ms. Kafer.
The residential proximity.
I would like to just register an objection, given that we are the party with the burden of proof, and that Ms. Kafer is eliciting information or testimony from Mr. Haynes regarding an alternative route that, while certainly was in the record, details about the relative benefits or detriments of that particular route versus the proposed route has not been previously elicited. There were, as everyone's aware, there were 729 routes. And so to now pick one to examine and compare to the proposed route at the very tail end of the proceeding, without an opportunity to cross-examine, is prejudicial to NETE Southwest.
Now, I understand your concern, and perhaps you can address that in your post-hearing brief, but Ms. Kafer, you'll continue on.
The residential proximity score of 34 for the Route 422, that's near the lowest on the list. Only fewer than the 58.
I don't know if it's
Ms. Kafer's question was broken up. If she could repeat that, please.
Okay, the residential proximity.
I'm sorry, now you're frozen, Ms. Kafer.
All right, I don't know what to do. What do I do?
What about if you take yourself off the screen right now,
Okay.
or can you bring your exhibit down?
I think if she just turns her video off.
Yeah, the video off might help.
You don't have to take down the screen share, but
There, that I don't want to lose again. Am I on?
Yes, ma'am.
Okay.
Yes, I can.
You can hear me all right now, Ms. Haas?
Yes, thank you.
The residential proximity score of 34 for Route 422 is near the lowest on the list, and it is certainly fewer than the 58 for the route that was proposed in the application, correct?
It is definitely lower. I don't know if it's the lowest on the list.
And when the category of public facilities within 500 feet, that for Route 422, that is 0, correct?
Yes.
Would you agree that with these scores, especially the low number of residential structures impacted, that Route 422 is a very viable option to be selected for the route?
We've not heard the whole record on the route, so there may be other things. And as I think it was pointed out yesterday, this model is really a screening tool. I don't know what all went into this. I will say that 422 appears reasonable based on our discussion. And that's about all I gave for the proposed route, by the way, as far as an evaluation, was that it appears reasonable using the methodology used.
Well, and so we've talked about how the weighting impacts the outcome and how putting this, routing it right next to an existing line really isn't that important, shouldn't have been weighted so heavily. So if the weighting on that one factor had been reduced, then this could have very likely been the route that jumped to the top of the list as the preferred route, couldn't it have?
It would have to model. I think what I would say, if I'm going to speculate on the model, is that 65 would not be the top route, change the weighting factor from 8 to something lower.
My final question is for the confidential session, so that's all I have. Thank you.
Thank you, Ms. Caper. We'll move to IBEW. Do you have
No
questions?
questions.
Thank you. Commission, do you have questions of the witness?
No, nothing further in public session.
Nothing from Commissioner French. Commissioner Keen, do you have questions of the witness?
No questions.
Okay, thank you. Staff, would you like to redirect?
Would I get to redirect after the confidential session, or should I can reserve to that, right?
You probably need to do that now.
Okay.
One other note, just for the record, during the pre-hearing conference in this matter, we did request as the applicant with the burden of proof to be the last party to cross-examine. I'm not sure why that was denied, but this is a perfect example of why the applicant with the burden of proof should be the last party to cross-examine. And I just want to note that for the record, I understand you overruled my objection, but it seems inappropriate, and I think the commission should take note of that for future proceedings.
Thank you.
If I may weigh in, I support and agree with Mr. Schulte's comment.
So is there no objection then from Evergy if we ask Mr. Hanos a few questions?
I have no objection.
The McGee's have lots of objections to that.
Just a moment.
If we're going to start changing the rules of the game right at the end.
Well, Mr. Kimmel, thank
That's
you.
absurd.
I am asking for the commissioners, please. Let's go to the breakout room real quick. Thank you. Okay, we are back. So on the request to, for staff redirect after, our closed session, you will redirect on the public portion, everything we've heard. On, NextEra's request to, recross, the request is denied. We're sticking to our schedule. Your objections were noted. So at this point, it is staff redirect.
Okay. I have only two questions. Mr. Hanos, did you make a recommendation regarding the route?
No, I did not. I, in my opinion, stated the route was reasonable. I did not make a recommendation as to which route should be selected by the commission.
If the commission decided that this route was unreasonable, what would happen?
I can only speculate, but I think if the route was unreasonable, NextEra would have to evaluate the amount they bid to see if that would cover their cost to take a different route. If it did not meet their economic criteria, they could reject the NTC. The process would go back to the SPP and they would rework the need for the line and also what the benefits of the line would be at this date rather than in 2019.
No further questions from staff.
Okay, thank you. Commissioners, another bite at the apple here. Commissioner Keen?
I will be very brief. I have one comment to make. It's in connection with the colloquy that Mr. Hanos had with Ms. Crawford and some of her questions. It strikes me that whether or not we have two lines, two single lines, or one double circuit line going through this 25-mile critical interval where you're either going to be parallel lines or it's going to be double circuited. In either event, Leo, am I not correct? Both of these utilities are going to have access to those lands of necessity. Isn't that correct?
They would have access, yes.
Yeah. End of story. That's my only question. Thank you, Chair Duffy.
Thank you, Commissioner Keen. Commissioner French.
No, nothing more public.
Okay. Mr. Hanos, you may virtually step down, but we will be recalling you into the next confidential session, so you will remain under oath. Okay, folks, we'll now be entering a breakout room to discuss confidential competitive matters. Specifically, we will be asking questions about Evergy's application to the SPP. This discussion will include staff and all parties that have completed a confidential competitive NDA. For the sake of efficiency, we will be asking questions of staff witness Leo Hanos and Evergy witness Steve Vetch. Mr. Kimmel, because you have not signed either of the NDAs, you will be excluded from this discussion. Okay.
Chairman, I appreciate that. I will note for the record my objection to the commission going into executive session to discuss those issues without providing sufficient basis for identifying why the information is going to be confidential. Thank you.
Okay, your objection is noted. Okay, at this point, Michelle's going to, she has a list and she will be moving us to a breakout room.
Hey, this is Rustin. I just saw that I just missed a call from you on my
Testing, testing, testing.
the last exhibit of the cabs. Okay, everybody, I don't know if got other folks coming back on. I don't see Mr. Kimmel, but I'm sure. There we are.
On.
Okay, all right, we're coming back in. Gonna wait a second. Okay, it appears that everybody is here. We are returning from our executive session, and this does conclude our hearing in docket number 23. Any
Commissioner, before you can conclude the hearing, I would like the commission to note the amount of time that was spent in executive session, and also identify the topics that were discussed in executive session.
For that we went into confidential session, I actually read what the matters were to be.
And I understood those matters to be Evergy's application. Is that correct?
Yes, it is.
I would object.
It was
Evergy's application to the SPP is irrelevant in this matter.
Objecting?
Are you lodging an objection?
That's exactly what I just did. I'm objecting to the commission entering into executive session to discuss Evergy's application to the SPP because that application is irrelevant to this matter.
I'm going to overrule that and I'm going to continue on, Mr. Kimmel. Thank you. So this does conclude our hearing in the docket number 23 NETE 585 STG. I'm sorry, who is talking?
Yes,
Mr.
I'm
Schulte?
very sorry to interrupt, but I was just reminded that we did not come back and clarify the guy structures in the double circuit, or no, I'm sorry, in the parallel area, the 25 miles or 22.5 mile parallel area, which was a question you had asked us to clarify before the close of the hearing.
Oh, please do.
There are 9 guide structures in the 22.5 mile parallel area. 8 out of the 9 have been are within areas where we have acquired an option agreement. And discussions are continuing with the one remaining landowner that will have a guy structure along the parallel area. For the entirety of the line, there are 43 landowners impacted by guy structures. And 21 of those 43 landowners have agreed to allow the guy structures through the execution of an option agreement for an easement.
Okay, I'm writing this down. All right, I do appreciate you, Mr. Schulte, providing that. I just didn't know if you guys were able to do that. Thank you. All right.
Certainly.
Okay. Okay, so this concludes our hearing in this docket. As a reminder, the order for this matter is due May 24th, and the briefing schedule is as follows. Simultaneous initial post-hearing briefs, May 12th, they're due May 12th of 2023. Simultaneous reply briefs are due May 15th, 2023. We do know this is a tight schedule. I suppose you can reach out to Ms. Hawes if you would like on the transcript, and she can respond to you. If there are.
Could you please identify the contact information for Ms. Hawes?
Just so you know, David Cohen will be in contact with you all with that information, okay? So if there are no further matters, we will adjourn. Thank you, everyone. It's been a long day, but thank you and have a safe journey home. We are adjourned.